All right, good morning, folks. This is the Colorado Oil and Gas Conservation Commission, July 7th, 2021 meeting. It is 9:30 and we have opened up the Zoom meeting for folks to attend. Look forward to a good meeting today. We've got a packed agenda. We will start with the roll call.
Thank you, Mr. Chair. Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mock.
Present.
Commissioner Mesner.
Here.
Commissioner Nanjapa. Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Excellent. Good to see everybody this morning. Glad to have everybody with us. People are still rolling in. I would like to call on Commissioner Hackett for a public announcement relative to a meeting this afternoon so that everybody's aware of it, perhaps.
Thank you, Chair Robbins. Just wanted to remind folks that this afternoon, the Air Pollution Control Division at CDPHE will be holding a stakeholder meeting today from 3 to 5 o'clock. And at that meeting, the staff with the Air Division, they'll discuss their intended rule strategies on how to minimize greenhouse gas emissions from the oil and gas sector. And there will also be a Q&A session at the end where staff will answer questions from the public. Just a reminder in terms of timing after this stakeholder meeting, the request for rulemaking would be at the Air Commission's hearing on September 16th and 17th. And it's anticipated that they'd set the hearing dates in December, I believe December 15th through 17th. But today's meeting again is from 3 to 5. Advanced registration is required. And Mimi, I may need to ask for your help. I'm going to paste in the comments the website for where folks can register. And once you register, your browser, the Zoom information will pop up and you'll want to copy and paste that and save that for your records in order to attend this afternoon's meeting. And I understand that some of the COGCC commissioners will tune in as well as part of our ongoing efforts to collaborate on these important issues. So we look forward to seeing you all there, and I'll go ahead and post that in the chat.
Excellent. Thank you, Commissioner Hackett, for that information. I know that I plan on attending. I would anticipate that other fellow commissioners would be attending. That would not be a commission meeting because we're not doing commission business. We're just listening in, unless AAG Davenport thinks otherwise. Yeah, we'll all hopefully be planning on attending. AAG Davenport, to give me a thumbs up on that. Thank you. And I also see that Commissioner Nanjapa is now with us. Good to have you with us. No worries at being a few minutes late. I know you had some things going on. With that, we will proceed into our agenda. And we start this morning with general public comment. We always have folks sign up, and we appreciate folks signing up so that we can kind of strategize what our agenda looks like. We had 11 people sign up. Everybody has 3 minutes to speak. Previously, we had a little bit of discourse around making sure that everybody was being civic in regard to their discussions, and people are doing a good job of that, and we really appreciate it. And we definitely look forward to hearing from you. I would note for the record that we did not receive any written public comment this morning. We encourage that, but we did not receive any. So with that, I would turn to Hearings Manager Larson and Hearings Manager Amaro to help us work through the 11 general public commenters.
Thank you, Mr. Chair. And I am looking for our public commenters. Lucy Molina is our first up, and give me one moment and we'll see if we can find her. So far I have not been able to locate her. Ms. Molina, if you are in the meeting, you could raise your hand. If that would be great. If I don't see you raise your hand, we will keep checking for you and come back to you when you enter. The next person we have signed up is JD Roybal. I'm also not finding Mr. Roybal. So again, Mr. Roybal, if you happen to be in the meeting, if you could raise your hand. If you're not here, we'll keep looking for you and come back to you as soon as you come in. Next is Tess Dougherty. And I'm not finding her either. Ms. Dougherty, if you are in the meeting and could raise your hand, we will get you keyed up for public comment. Oh, I see a raised hand. Well, it's Miss Marie Venner, who happens to be next on our list. So we will move Miss Venner over as to a panelist, and we will start the clock for her as soon as she is in.
Ms. Venner, it looks like we've made you a panelist. If you want to unmute yourself, we look forward to hearing from you.
Good morning, commissioners. I want to urge you to begin to offer on your agenda equal time that you've given to industry presentations, that you begin to offer equal time to everyone else. This is critical. The approach to date is not adequate or fair, no matter how well-intentioned you are. On behalf of multiple organizations, I'm asking and insisting that you rectify this in the next couple of weeks. The Commission's #1 job by law is protection of public health and safety. It is not protecting the returns to industry, anticipated or otherwise. Colorado has commitments, not least producing dramatic reductions in emissions and improvements to our air quality. Yet Colorado lacks continuous monitoring, assessment of cumulative effects, and our state has been placed in great financial jeopardy through blanket bonding. Even North Dakota knows that blanket bonding makes no sense. Even North Dakota is requiring at least $180,000 per well until adequate restoration occurs. This may be an old number even. We know in Colorado that the average cost is around $270,000 per well. And there is a well in Windsor that has cost over $1 million and is still not shut. Funds should be deposited in trust until the work is done. If a business is not able to cover this, they may not be mining any longer, but at least in Colorado, we'll be gaining fiduciary responsibility and the COGCC will be avoiding negligence. As a commissioner, it would be nice and simpler to think that you are only on the line for following regulations, but you are also subject to Colorado law and responsibility for executing Colorado law. You can be sued in your position of responsibility for not following Colorado law. I urge you to follow the law and not just take the advice or advertising of industry that you get in your presentations. And just asking them questions is not enough. You're still receiving that advertising and you need to give equal time to other information. Our region has the 3rd worst ozone in the country after LA and California's Central Valley. The bulk of the VOCs forming that ozone come from fracking. Our air quality has been in violation for a decade and is now at a severe level, the worst possible level, and still getting worse. With the air pollution situation, 2019 laws and the requirements on the books and the climate risks facing our state, it seems like no further permitting should be a no-brainer, at least until all the required air pollution reductions have been achieved and thoroughly documented. No disproportionately impacted communities are being impacted. Closures for all wells are completely covered by the drillers and owners, etc. This is owed to the people of Colorado, and it is to the people of Colorado that staff and the commission owe the greatest service and accountability.
Ms. Venner, I
Last sentence. If you are behind, it is imperative to catch up in these areas first. Please start by allocating equal time so you can get good data. We are here to
Ms.
help.
Venner, you have exceeded your time. I apologize.
That was it. Yeah, I timed it. Sorry, it evidently went slightly longer.
So thank you. We will now move on to Jerry Shepherd. So one moment and we will bring Jerry into the meeting.
Good morning. Are you ready for me now?
Yes, we are, Ms. Shepherd.
Yes.
Okay, thank you very much. Thank you all for the opportunity to address you. My name is Jerry Shepherd. I live in Greeley. And of course, you may understand some people called Weld County, Weld, W-E-L-L-E-D County. And the worry obviously is that climate change is a thing. It is real, and Colorado is affected as other states and the rest of the planet are. And the worry is that if we fail to have any accountability to oil and gas, we will continue to accelerate the worst aspects of climate change. I just saw some figures online. Last year, 1,505 wells were approved, and in this year it's looking like the wells were approved in the hundreds. And the worry obviously is, when there is an accident, when there is spillage, things that happen that should be planned for but are not, guess who gets stuck with cleaning it up? The people who own the land, the taxpayers, the people who get sick from the fumes, future generations. Economists use the term externalities to talk about the costs that are imposed, not absorbed by the people who do the business, but are imposed on others. And that means that, in essence, oil and gas production is artificially cheap. We need to rethink this. And at the very least, we need to be getting full cost bonding on all wells. We need to, in essence, have the industry who causes the pollution to be the ones cleaning it up. I know when I was a kid, if I made a mess, guess what my mother told me I had to do? Clean it up. Were the oil and gas people not listening to their mothers when they were told to clean it up? Sounds like they weren't. And of course, Mother Earth herself says, clean it up. So that's something that we need to be working on. I agree with the previous poster about having equal time for citizens to speak. I will also remind this panel that Bella Romero still has wells and the monitoring has been insufficient at best. We need to work towards a 2,500 foot setback for houses and schools, and there needs to be full accountability. Unless you have any questions, I think I am done, but I urge you to hold oil and gas accountable. I urge you to rethink our reliance on oil and gas, because the relationship is a dysfunctional one. We, the citizens, are like drug addicts and they are the pushers, and it's that kind of dynamic. And I think it needs to change, because what's going to happen to our planet? What's going to happen to our children and grandchildren when they don't have a safe place to call home? Thank you very much for your time.
Thank you. Ms. Larson, you're muted.
Thank you, Mr. Chair. Next up, we have Guillermo Cerna, and I've not been able to locate Mr. Cerna in our attendee list. So we will then move on to Wes Wilson.
Good morning, Mr. Wilson.
Yes, Mr. Robbins, can you hear me?
We can hear you. Absolutely. Look forward to hearing from you.
Okay. I just wanted to bring up some terrible financial history. Last year, PetroShare went bankrupt. And it's just one of many. When PetroShare went bankrupt, its largest creditor was Dallas-based Providence Energy. And it had loaned that Inglewood company some $25 million through yet another subsidiary. But under the terms of that agreement that Providence negotiated with PetroShare, the COGCC and the state attorney general were given 90 days to decide which of PetroShare's assets the other company, the next company, was going to buy, and which of them they considered worthless. On top of that, the COGCC identified a number of those sites as having spills and other regulatory violations, at least at 25 of the wells. And a former Commissioner Boygan put it this way. So basically, PetroShare, can make the decision not to take all the bad wells, or the wells that have enforcement issues, and just take the clean wells, the clear wells. That's the financial situation this state has put us taxpayers in. You're creating additional orphaned wells. It must stop. It will stop if we, the people, get from this commission what is demanded by law. And that is to assure that you have adequate cash bond in hand and do not allow these companies to run their current business schemes of running bankruptcies for profit for a few CEOs. I thank you. I look forward to working on the financial assurance regulations to make sure that the type of thing that PetroShare pulled off on this state of fostering its dirty and now orphaned wells onto us taxpayers. Thank you.
Thank you, Mr. Wilson.
Mr. Chair, I see Ms. Molina has joined the meeting, so I will bring her in for her public comment.
Good morning. Can you hear me?
Yes, Ms. Molina,
Buenos dias.
we can hear you.
Okay, sorry about that. Well, first, I would like to apologize for I missed the last meeting I signed up for. I was sick, but I do want to thank you again, all the commission, for your public service. Again, you know, it's the health impacts, the migraines, the cancers, and the impacted communities that we're affecting. Now we're struggling with a lot of different health impacts: cancer, diabetes, asthma, and all these issues. And the list goes on. I ask the commission to be considerate. Another thing, we are facing a climate change, right? We are facing a climate crisis. There is no time. Time is running out. And also, the land never heals. Water, air is a human need. I really hope that this commission starts listening to the residents and start putting people over profit. Again, I thank you for your service. And I know it's not an easy position that you're in, but I know that life is important. Life matters. And I really hope that you begin to listen to us, listen to the community, listen to the people, and start protecting us, please. There is no time. Time is running out, and the land never heals after it's being fracked. Again, I thank you for your service. I hope that you begin listening to the community. And yeah, thank you so much. God bless you all. And I will see you the next time. God bless you.
Thank you, Ms. Molina, and glad to see that you are well and with us again.
Chair, next up, we have Steve Douglas.
Hello, this is Christy for Steve. Steve had to go back to work, and so he's not able to join this morning.
Very good. Ms. Douglas, you also signed up, so we'll allow
I
you
did.
to have your 3 minutes now.
All right, well, thank you so much. Thank you for commissioners Oh,
So you can
sorry
turn,
about that.
turn,
Sorry about that.
yeah, no problem. Turn your phone off and or put it on silent, and we have not started your
Okay.
3 minutes, so you
All
have
right.
the full time.
Okay, very good. I don't know how to, I'm trying to turn my phone off. Hang on just a second.
We'll bear with, no problem.
Oh, sorry about that. I can't get it off. Anyway, I'll just put it somewhere that hopefully you can't hear it. I just want to thank you, commissioners, for having continued public comment. And I also like to thank you for that you're having it remotely and you continue to do that. That really makes it easier for the public to show up and to speak. So my name is Christy Douglas. I hail from Commerce City, which is in Adams County, and I serve as the co-chair for NRCC, which is North Range Concerned Citizens. And I've been asked to speak in behalf of all the people who couldn't be here this morning to speak. I would also like to acknowledge again that we are living on stolen land and we should recognize that fact and know that we need to show the land respect. So I listened again to the presentation that was given a couple of weeks ago. She took a week off. That was done by Susan and Jeremy from Great Western. Susan is the Senior Vice President of Sustainability and Government Affairs, which I thought was interesting that they would have somebody in a position such as that. Sustainability, that means that she's trying to keep the business going. And obviously she, since her job title is Government Affairs, that means that she is also the liaison to Adams County, and she has quite a presence here. I found Susan very charismatic, and I found Jeremy quite charming. And I thought they did a really great job of kind of explaining away everything, their whole process. It seemed like it was really sugar-coated what they do. Sorry about that. Anyway, I want to echo what a previous speaker, Marie Venner, said. And she said that we need to hear from the other side. And I think the next speaker also said the same thing. You're only getting one side of the story. And from what I understand, the people who are in this commission aren't necessarily experts in the field of oil and gas. And so they're learning as they go. But how can you regulate something if you don't really know about it and you're only getting one side of the story? So I really encourage you to seek out presentations from scientists and medical experts, and then people who are impacted so that they can tell their story.
Ms.
So
Douglas, I apologize for interrupting, but your time has expired.
well, I appreciate that. I do apologize for the interruption from the phone. It was Guillermo. I think he might be on the phone and he can't raise his hand if he's on the phone. So he called
We'll try to
twice.
find him.
Yeah.
All right, if you could do that, I'd really appreciate it because he was the one that was calling me.
Okay,
So,
let's
thank
see if
you.
we can find,
He's a neighbor of mine from Commerce City. So,
yeah, let's see if we can find him.
all right, very good.
Well-
Thank you so much. I appreciate your time, and please consider what I said.
Okay, thank you very much. And Ms. Larson, I see in the chat that Mr. Wilson suggested that he had concerns in terms of who he could see. I think that's on his end and not on our end, because I can see all the commissioners throughout these presentations. Is that right?
I believe so. I can certainly go ahead and I've changed it now on my side. I see all the commissioners.
If you pick side by side gallery in terms of
Mhm.
what you're looking at, then you will be able to see everybody. So just FYI on a Zoom situation, And Mr. Cerna, if you're in the Zoom with us, if you could raise your hand or give us a heads up in terms of what phone number you're on.
Yes,
See a
there is
2713 number, maybe that's it.
perhaps, well, Ms. Douglas is raising her hand. She may have his phone number. Ms. Douglas, I don't know if you're able to speak.
Yeah, yes. So yeah, he said he's on and he's been trying to get your attention so that he can speak. And
What's his phone number, Miss Douglas?
let me see if I can pull it back up again.
You don't need to tell us all the digits, but just maybe the
I
last
will.
couple digits.
Okay. He might be on the number 2532, but he might be on his landline too. So if there's somebody on the phone, that's him.
Okay, we'll bring we only have one phone
Yeah,
participant.
he
We'll
can't
bring
raise
them in.
his hand on the phone. I mean,
Okay.
there's no way that he can get your attention.
Oh,
So
we'll bring them in. Thank you.
Miss Trask also chatted about being only able to see one person, so maybe we can try to work on that too.
Okay, I have changed my view. So I see all of the commissioners. I'm gonna ask Ms. Amaro to come over and she's going to hopefully fix it. Give us
Okay.
1 second. And while we're doing that, the phone number that is in the meeting, we've unmuted them and are asking that attendee to speak. So far, they've not spoken. So perhaps that's not Mr. Cerna.
So you have to tell him which numbers to push, like *6 or whatever, to unmute himself. It's not unmuted on a phone, and I used to experience that all the time before I had access to a microphone on my computer. So just so you're aware of that, I mean, it was impossible. You would say, raise your hand. It's like, I can't raise my hand. And if you're
Okay, thanks,
not
Ms. Douglas.
unmuted,
Well,
all right, thank you.
we're doing everything we can. Mr. 2713, if you would like to speak, you can unmute. You might hit *6. You also may not be wanting to speak. We just don't know. Ms. Larson, we have phone number 2532 that just joined, and I believe that was the number that Ms. Douglas said was Mr. Cerna. Perhaps
It is
we can
indeed.
bring him to the fore, and we can move 2713 off the panel. Mr.
Hello.
Cerna, are you with us?
Yes, sir. Yes,
Excellent. We're glad
I'm
that
here.
we were able to find you, and you have 3 minutes.
okay, well, it's very disturbing in perspective to how you pick us up and how you don't pick us up. You put us on mute right away. We're talking to a machine and we're not talking to a person. And then we can't call in because every time we call in, it's busy or whatever. But I only got 2.5 minutes left. So, look,
Mr. Cerna, let me stop you right there, and I'm going to stop the clock, because I think that our commission is doing an excellent job of having public be able to participate with us. And so I take offense that you think that we're not. We're doing everything we can to make sure that all members of the public are able to attend with us and to speak to us throughout the course of our being. We meet every week. We have public comment every week. On the evenings, once a week, we do 5 minutes. So I take grave offense to that. Your time is going to start back up, and why don't you speak substantively to us with regard to the time you have left?
thank you very much. With all due respect, the decisions that you're going to have to be making here pretty soon, and you're going to be listening to the people that take a look at the air and all that type of stuff. We have to start looking at And you're going to have to make a decision as to whether you want to go on with oil or whether you want to do the right thing. By the time we get all of this rules and regulations and whatever we do or you do in recommendations, we're going to be already almost in the 30s. And look, it's got to be done before 2040, 2045 in order for this world to be safe in America. Concerning the worldwide situation, we are that leadership. Nothing gets done without our input. Now, we should be looking at the future of our kids. We keep sending ships up, heavens knows where, to understand where we come from and where we're going. Our kids don't have that. They don't have that. They gave us a brain to think of how we can protect ourselves and how we can make it better every time. But all I hear is one side, and that's just my opinion. And I can apologize with all due respect, but sometimes people have sugar diabetes, people are on pills and this and that. So I'm not going to apologize for my health situation here at home or with the family or whatever. Sometimes you catch us at the wrong time, the same way I just did you in perspective. But I try to look at it from both sides, but we're not getting it. And everybody else can say what they want, but when the parents or people out here as shareholders do it, we get comments like you. You're supposed to be the leadership position. And I hope and each one of you can take a look at where we're going for Colorado, for God's sake. Fires everywhere, no water in a sense. We're going through a drought. And we keep asking why.
Mr. Cerna, I
And
apologize, but your
you're
time
welcome. You're welcome.
Okay, thank you. Mr. Chair, so we still have, oh, go ahead.
I was just going to say, from my count, we've got Mr. Roybal, Ms. Daughtery, and Emmett Hobley that had signed up, as well as Ed Ingvey, potential speakers that are left.
That is correct. And unfortunately, we do not see any of those individuals in the meeting at the moment.
Okay. Again, we encourage public comment each week. We have folks sign up, and if they don't make it, that's fine, but we do give them an opportunity to participate. I participated before this commission as a private attorney for a long time, and I do know that our public comment ability and availability is 100% in good space right now. With that, I think we will continue down our agenda, and I would turn to Commissioner Mock for a report from the Executive Director's Office of the Department of Natural Resources.
Morning, Chair Robbins, Director Murphy, members of the Commission, Tim Mock, Deputy Director for the Department of Natural Resources. A couple of updates here. All of our legislative bills pertaining to the Department of Natural Resources have now been signed into law by the governor, including the groundbreaking policy achievements for Colorado Natural Resources pertaining to our outdoors, including the Keep Colorado Wild Pass and the Create the Outdoor Equity Grant Program, which establishes the Outdoor Equity Board in Colorado Parks and Wildlife, responsible for the governance of the Outdoor Equity Grant Program to increase access and opportunities for underserved youth and their families to experience Colorado's open spaces, state parks, and outdoor areas. We've also had some significant investment on our public lands to bridge these initiatives and the time in which they get set up, which we are currently moving towards the implementation phase. But this bridge funding invests about $25 million to support some key parks and wildlife needs, including $15 million for new state park infrastructure, $3.5 million for state park staffing, $3.5 million to implement the statewide wildlife action plan and conservation of native species, $750,000 to the Colorado Avalanche Information Center, and $2.5 million to Search and Rescue Fund. And then finally, $1 million to the Outdoor Equity Fund for use by Colorado Parks and Wildlife to implement that Outdoor Equity Grant Program. Through this session, we also received significant investments in wildfire suppression, as well as the recovery of our lands and watersheds totaling $88 million. I'm certain you've been apprised of those details and happy to go into those if there are any questions. We have begun implementing this package of bills. In fact, last week we met to kick off the rapid fuels reduction planning with the Forest Service, BLM, State Forest Service, and Colorado Division of Fire Prevention and Control. DNR's posted 2 temp positions that will last for 3 years and will assist in implementing the DNR wildfire mitigation program. We also received $20 million to the Colorado Water Conservation Board for the Colorado Water Plan. In some other news here, the Colorado Geographic Naming Advisory Board is now meeting regularly. Our next meeting is next Thursday, July 15th. We are currently considering 2 proposals to rename reservoirs on private property in San Miguel County. On our DNR website, there's more information about the Colorado Geographic Naming Board, and we'll be meeting every month on the 2nd Thursday. Wolf reintroduction, according to Proposition 114, is proceeding forward. Both the stakeholder and technical working groups are now meeting regularly. The SAG, the Stakeholder Advisory Group, met June 25th in Salida, and I understand that that meeting went very well. The next public open house meeting for wolf reintroduction is July 12th in Steamboat Springs. There are additional updates on Colorado Parks and Wildlife's website, including the wolf educational series that were some online seminars. Those 3 series can be viewed as well from there. Regarding state of emergency, drought proclamation, and funding, last month the Drought Task Force made a recommendation that the drought emergency be declared by proclamation of the governor for 21 West Slope counties. The proclamation was signed on June 30th. A drought emergency proclamation is recommended step associated with phase 3 of the state drought plan. It is an opportunity for the governor and state to raise awareness of drought conditions, potential and active impacts, and signify increased readiness and support to state and local efforts to provide emergency services as needed. The proclamation acknowledges, or a proclamation generally acknowledges, an event or person and offers the governor's support without creating particular obligation to the state. And this does not open state emergency funds, but an executive order can do that. And state agencies continue to meet and monitor conditions closely and prepare for next potential steps. Just in here, due to extremely low flows in warm water temperatures, Colorado Parks and Wildlife is asking anglers to voluntarily avoid fishing on the Colorado River between Kremling and Rifle. There's also some restrictions over on the Yampa that I am aware of. And then turning towards the State Land Board, a couple of updates that you may already be aware of. Staff presented at the last meeting to commissioners a comprehensive renewable energy development framework for solar on trust land. It incorporated feedback and data from other state, federal, and industry leaders. The plan identifies trust lands, acres that are most preferable for solar development, as well as trust land properties least preferable based on existing uses, sun asset availability, nearby transmission capabilities, land ecosystem attributes, and other factors. And then a bit of fun news here, the State Land Board has installed 2 beehives at 2 of its commercial real estate buildings in downtown Denver as part of a pilot urban beehive project. And so that concludes my department updates. If there's any questions, I'm happy to entertain. Thank you.
Who gets the honey?
That's a great question. I was wondering that myself. I'll let you know.
No, that's excellent. Great. Thanks for the comprehensive update there, Commissioner Mock. We really appreciate that. It's good to hear about all things going on with the department. And I see that everybody can see everybody, so great job to our staff for getting that fixed. And with that, I would turn to Director Julie Murphy for a report. Update.
Thank you, Chair. Thank you, Commissioners, and thanks to folks listening to us. I might have heard a little feedback, seems to have corrected itself. A couple of quick things. One, I wanted to note that we have received a few oil and gas development plans, or OGDPs, and 3 of those have been noticed for hearing so that the public and stakeholders are aware that we are going to be able to have this commission begin to test drive, for lack of a better term, the rules that were adopted last fall. I'm proud of the work of staff that has gone into those to get through completeness, and now we will be engaging in the technical review of those OGDPs in preparation for submitting a director's recommendation. Those are all available on the website. Second, we've had a couple of staff members leave in the last month. Ted Dinkler from the engineering team, and also Lou Colby from the reclamation team. And so we're kind of assessing and thinking about what that means more globally for the organization. And this is a hardcore organizational update. Scott Cuthbertson is leading a review of where we need different or more staff needs, right? We held open a number of positions last year in light of some of the budget challenges. I think that gave us the opportunity to also adopt these mission change rules and think about what different or other skills or where we need people as a result of those rule changes and what our objectives are as a result of those rules. So we're looking at the organization as a whole and thinking about where to use the open FTEs that we have to make sure that we are achieving both the statutory and regulatory objectives of the commission. I think that that's an important piece of work and I'm really proud of it. But probably more to come on that. Again, it's highly operational, but I want you all to know that we are thinking about what landscape we've created with these rules and how staff will achieve those objectives. So with that, I think that's the sum total of my update. Chair Robbins, if there are any questions, I'm happy to take them. Otherwise, I really look forward to Ms. Danzig's presentation. She's one of the most informed, in my estimation, around how spacing and protection of subsurface resources can work and what this agency has done. So she's just a wealth of knowledge and look forward to, again, learning from her in just a few short minutes.
Great. Thank you, Director Murphy. Are there any questions for Director Murphy? All right, seeing none, we'll continue down our agenda. The next, just to kind of frame up the next 2 items. So we have a staff presentation from Jane Stanzik, our permit manager, about unconventional resource units. And then that's followed up by a yearly presentation or check-in by Great Western Operating Company about an unconventional resource unit that was established by the Commission in order number 535827. So why don't we turn to Ms. Stanzik? I see you with us. Good morning, Jane. Great to see you, and thanks for being with us and educate us again about this matter.
Great, thank you. Good morning. Good morning, Commissioners. My name is Jane Stanzik, and I manage your Permitting and Technical Services Group. Today, I'll provide a brief overview of the unconventional resource units the Commission approved from 2013 to 2017. First slide, please, Angelica. Unconventional reservoirs have production challenges such as extremely low permeability, uncertain reservoir extents, and lack of energy to drive the resource to the well. Recent improvements in drilling horizontal wells and in hydraulic fracturing treatment have made these previously uneconomic reservoirs productive and profitable. Operators in Colorado began implementing these techniques on a wide scale between 2012 and 2013. The Act's drilling and spacing unit and unitization provisions contemplate conventional reservoirs. Therefore, these unconventional reservoirs had to be approached somewhat differently while still complying with the Act. For example, the pool in an unconventional reservoir can be basin-wide, and the boundary can be difficult to determine. In addition, traditional enhanced recovery methods are not applicable, and numerous wells are typically required to drain the resource. Next slide, please. The Unconventional Resource Unit, or URU, is a hybrid between a drilling and spacing unit and a state unit that is unitized for enhanced recovery. Operators appreciate the flexibility available under an URU. Like a state unit that has been unitized for enhanced recovery, URUs recognize the uncertainty in the number of wells required to fully develop a unit. And they do not require commission approval for evolving development plans and operations. The guiding principle of URUs is the statutory requirement that the pool as a whole will be efficiently and economically developed. Next slide, please. This table compares traditional drilling and spacing units, or DSUs, state units unitized for enhanced recovery, and URUs. For operatorship and unit operating agreements, DSUs do not designate a unit operator, but both state units and URUs do. The Commission does not approve a unit operating agreement for a DSU, but does for all state units and has for some URUs. For well count and subsequent wells, a DSU is initially created for a single well, and additional wells require subsequent Commission hearing applications and orders. State units and URUs are approved for the appropriate number of wells, granting the operator authority for that determination. For surface locations, the Commission orders for all units may limit the number of surface locations. Involuntary pooling. Non-consenting mineral owners in DSUs and URUs may be pooled by Commission order, but the unitization statute and the unit agreements relating to a state unit address non-consenting owners, so pooling by Commission order is not necessary. Commission review for unit development. Commission review of unit development has not been included in orders for DSUs. State units have a required hearing if approval had not been obtained from 80% of the owners at the time the unit was approved by the Commission. The Commission orders for URUs have required an annual review of unit development. Next slide, please. There are some concerns about URUs. Some mineral owners have been concerned about the large size of these units and the potential for a single producing well to hold multiple leases without continuing development. Some working interest owners have been concerned about the cost uncertainty due to the undefined number of wells. The operator's annual review before the Commission provides an opportunity to address these concerns. Next slide, please. The Commission has approved 25 URUs and has subsequently vacated 17 of them. This information describes the 8 remaining URUs in the state. 4 operators have URUs. They were created from 2013 to 2017. They range in size from 640 acres to 4,800 acres. The number of wells drilled and completed in the URUs ranges from 1 to 54. Next slide, please. There are 7 URUs in Weld County and 1 in Moffitt County. Next slide, please. The Commission approved 18 URUs for Axia in Moffitt County in 2013. Axia only drilled one well in one of their Urus, highlighted here in yellow. Axia sold their assets to SWIN in 2014. Leased mineral owners presented their concerns regarding lack of drilling in the Urus to the Commission on multiple occasions. In 2015 and 2016, SWIN requested the Commission vacate the 17 undrilled Urus. Next slide, please. This is the one Uru in Moffitt County. Next slide, please. The Commission approved 5 Urus for Noble in Weld County in 2013 and 14. Noble has drilled and completed 182 wells to develop these units. Next slide, please. The Commission approved 1 Uru for High Point in Weld County in 2015. High Point has drilled and completed 17 wells to develop this unit. Next slide, please. The Commission approved 1 Uru for Great Western in Weld County in 2017. Great Western has drilled and completed 1 well to develop this unit. This concludes my presentation. Do you have any questions for me?
Thank you, Ms. Stanzik, for the presentation. I'll start with a question or two just to kind of peek around the edges on this topic. But the Uru is the downhole sort of spacing. It's different than the DSU. It's a different approach. But so, for instance, we're looking at the Great Western DJ Basin Uru. They still need to come back and obtain an OGDP at this point under our rules to be able to drill within the Uru. Is that accurate?
Yes, and Uru is kind of a special kind of drilling and spacing unit. It is all about downhole development. What it did, the concept was to provide the operators with flexibility. With the advent of horizontal drilling to develop these unconventional resources, the operators wanted more flexibility to actually figure out how to do it. It's kind of an unknown in 2013 when this all started. A bit of an unknown as to how many wells would be required. So this concept was just to give them some extra latitude to work out how best to develop these unconventional reservoirs. And yes, any location has to be permitted. Now a location needs an OGDP, all the wells have to be permitted. There's no difference in that. It's just what the spacing, how it works, how large it is. You can see that some of these are really quite large, which is unusual for a DSU. The idea of a DSU being it's for 1 well and then maybe additional wells are needed. Where the Urus started off as very large to give the operators the opportunity to figure out how best to develop with horizontal wells.
And I guess what I was trying to get at is, and this sounds really technical, but just to kind of get at it, is that our rules that we adopted effective January 15th that are our mission change rules that ensure that if we approve an OGDP, that it is protective under our new mandate from SB 1920. All of that is still in play with an Uru, and none of that is negated by an Uru. And you know, we're still looking at the same things as that development starts to come out. And that might be self-evident. I just want to make sure that we've got a record of it.
Yeah, you're absolutely correct.
Great. Thank you, Ms. Stanzik. Commissioner Gonzalez and then Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Ms. Stanzik, for the presentation. I've got a question about kind of DSUs and their interplay with URUs versus state units. It's my understanding that with state units, you can have a DSU within that state unit or several, and the wells can then be paid and the production allocated based on those specific DSUs. does the URU, and correct me if I have that wrong, but I thought that's what I remember from the state unit presentation. Does the URU allow for DSUs within the URU, or is it itself its own unit? So it's not just for holding leases and for unitization of the production, or I'm sorry, unitization of the leases within that URU, but it's also unitization of the production within that URU, meaning that everyone in that URU is paid the same. Do I understand that correctly?
Yeah, it's like a giant DSU.
Okay. Thank you.
But actually, Commissioner Gonzalez, back to your statement about a state unit. So typically the unitization to create a state unit occurs for enhanced recovery, typically. And that happens after the initial development of a field. So in the initial development of a field, there is spacing as whatever is understood about how best to develop that reservoir. Upon unitization, the mineral ownership is reallocated across the entire unitized area. So then going forward, once it's unitized, the payment isn't by those original DSUs.
I may have some conflicting kind of understanding in the difference in the space unit between a secondary recovery state unit or kind of the virgin new state unit, the
Right.
greenfield state unit, as is being contemplated, I believe, by Chevron at
Right.
this time for one of
Right.
their operations. And in that case, it's my understanding that the wells that the ownership is unitized, but that the production is allocated on a DSU basis, and that's kind of where I was trying to understand that differentiation.
Right. And that's another take on unitization, what Chevron is proposing.
That helps. Thank you.
Mhm.
Sorry, Commissioner McGowan.
I am feeling like a very slow student today. I apologize. Okay, so it seems like the commission has not approved unconventional resource units for some time. Do we no longer do those? That's one question. And then the next question is, why wouldn't we just require a comprehensive area plan for them to figure out how to develop such a large area that's already been conventionally developed? I'm having a hard time understanding the usefulness of this particular thing versus other tools that we have and why this is so unique. I'm just having a hard time understanding. I'm sorry.
It goes back to the history of the development of these unconventional reservoirs, particularly the Niobrara formation and the Codell, that section in both Moffitt County and in the DJ Basin in Weld County. At the beginning of the use of the horizontal drilling, no one really knew. The operators didn't know, we didn't know exactly how that would play out. And the operators requested somewhat larger than usual units to give them the flexibility to develop the resource as they grew in their understanding, as they acquired an understanding of how many wells they needed, all of that. So they came to the commission with applications, and the commission, excuse me. Sorry. And the commission approved them as this kind of a hybrid that isn't exactly like a one well DSU. Since then, a much greater understanding has been developed. And so that has reduced the need for this kind of a unit. And the commission has been comfortable in actually approving relatively larger than historically were common DSUs. So we actually have some DSUs that are as large as some of the Urus. So it was something that evolved in trying to accommodate this new development, these new techniques, and to have spacing as needed for the efficient and economic development. So it evolved, and we're still evolving.
If I may follow that a little bit, I think again, the thing to keep, I think Jane highlighted that transition period, and I think that these were an important tool at the time, recognizing the transitive state. The piece that I just want to take us back to is, again, that this is really focused on the downhole mineral development and protecting mineral owners. And as it played forward, I think, I guess, two things. One, the URUs had annual check-ins because they were novel and unique, and the commission wanted better oversight of them historically. And what we've learned from them has now fed into our existing rules around drilling and spacing units and consideration of mineral owners. But I just want to take us back to remembering that these subsurface boundaries are really about how the minerals are developed and how then mineral owners are compensated for the development. And it's really separate and apart from the surface component and surface impacts. But again, I think Jane really described it nicely, talking about how this was a transition piece and a learning curve. And as we've moved past it, some of our experiences have suggested that a traditional drilling and spacing unit is a better way to zone the minerals, even for horizontal development. And so that's how we've shifted, is back into the traditional drilling and spacing unit concept for horizontal wells. I don't know, Jane, if that, if you want to add anything to that.
No, thank you, Director Murphy. That's exactly it. Initially everything was so different. And the idea of having a drilling and spacing unit that was 2 sections, 3 sections was unheard of prior to 2012, 2013.
Commissioner Messner.
Thank you, Mr. Chair. And thank you, Ms. Stanzik, for that presentation. That was helpful as far as better understanding it. I do still have a few questions in no particular order, so I'm going to jump around here a little bit. But first question is, do these Urus have some sort of sunset, or are they in place for perpetuity, or how does the timeline of the Uru work?
It's the same as a DSU. If you look at the orders, there's no termination.
Okay. So understanding that, what is the purpose of the annual review for the Uru then?
Well, the concerns, especially initially, with the large size of them being unusual for a DSU, and the concern was, tying up a large tract of land with maybe just one well. And also just that it was all new. The commission wanted to have an annual check-in for the operator to report what they had done so far, what their near-term and far-term plans were. Just as Director Murphy said, to have continued oversight. As you know, DSUs are approved and there's no return to the commission to talk about what's been done. So because it was different, the commission felt that was appropriate.
So understanding that, what I guess what authority does the commission hold in the annual review of the Uru as far as determining that it's appropriately being used, or there is consistent activity or things of that nature to alleviate the concerns of potential mineral owners that are saying that the operator's sitting on it?
Well, historically, it's been a discussion, and the great example is all of the Urus that were created in Moffitt County for the operator Axia. The wells that they drilled there are predominantly gas. And at the time, the market was fairly weak and they were marginally profitable. And so they did not develop, they only developed one of the Urus. They drilled some other wells that were not in Urus. And they did not continue the development because of primarily economic reasons. And so when their annual reviews occurred, mineral owners came and presented to the commission their concerns. And the discussion did lead to SWIN, who had then acquired the assets, filing applications for those Urus to be vacated. So there's nothing in the rules or statute or even in the orders that say this is how it's going to happen. It's just that there's an update and it's an opportunity to talk about any concerns that staff or the commission or other stakeholders have concerning the Uru that's being reviewed.
May I add to Jane's comments?
Yeah, and I just had kind of a follow-up question, is that, so it remains within the authority of the commission on an update to cancel, revoke, undo an Uru, it appears to me. Is that right?
Chair, that's what I was going to chime in on. Historically, what we did with the SWIN Urus to effectively dissolve them was to renotice some mineral owners. And so I think that the annual update is to let commissioners know the status. And if the commissioners or the operator wants to change the terms of the order, it would require notice to all affected parties and kind of a more formal hearing process. But I think that has been, to me, the real purpose of the updates is to understand where things are, where they're going, and give the commissioners an opportunity to chime in. I think the commission has the authority, and I shouldn't be saying this probably, but we'll let AAG Davenport correct me. I think the commission has the authority to change any order that has been previously adopted with appropriate notice and hearing process. And this would fall within that category as well.
AAG Davenport, would you mind weighing in on this from your legal perspective?
Thank you, Mr. Chair. Commissioners, I don't have much to add from what the director just said. I agree with the process that effectively the commission would need to notice and hearing before it could make changes to the orders. It could not, for example, make changes today to that order. It would require additional process and hearing and notice. I think the purpose of the update is certainly to answer your questions, to understand what's going on out there today, and to see if you think follow-up is necessary after getting the information today and getting your questions answered. I am pulling up the Great Western Order and believe it should contain paragraph 2 of that order that was entered in 2017 does specifically state that the commission expressly reserves the right after notice and hearing to alter, amend, or repeal any of the above orders.
Okay, Commissioner Messner, we've all talked over you. You had the floor, so I'm giving you the floor back.
No, I appreciate that, Chairman Robbins, and that was actually my next question anyway, was to affirmatively acknowledge that authority, lies with the commission. I think understanding that, I guess my question is if we were, and I'm not suggesting anything, right? I'm just trying to understand the Uru and the process and the whole gamut here. But with today's rules and today's process, would these Urus that are in existence be treated more like a standard drilling and spacing unit, or do you think they would still need special circumstances?
Ms. Stanton?
Well, as Director Murphy described, the Uru is about downhole development, and all of the new rules are primarily focused on what happens at the surface. So I don't think.
So
Just
let's ignore the new rules piece and just say now we've got, a standard drilling and spacing unit that acknowledges and understands that the acreage involved is significantly bigger than perhaps was being contemplated in 2012 when the Uru was being developed. If an Uru was vacated and then re-permitted for a drilling, would it be re-permitted as a drilling and spacing unit, or would it still need additional flexibility, which is ultimately my understanding of what the Uru creates?
Well, it would take an application in order of the commission to change it. If you're suggesting a change that would dictate the number of wells to be drilled within it, rather than have it be worded as the appropriate number of wells, kind of open-ended. That's would, I suppose, I mean, the commission can make that application, I guess, or a mineral owner. As this has evolved, as we already talked about, this Great Western Urus, the last one that was approved, that was 4 years ago. And since then, we've been received applications, and the commission has approved large DSUs that do dictate the number of wells and such. I can see that there are cases where an operator may ask for an Uru, may ask, apply for the commission to approve another one. And they would have to make their arguments as to why a traditional DSU doesn't provide what they need for the development of their minerals. Sorry, that's a terrible answer.
I think generally, Commissioner Mesner, staff has generally thought over the course of the last 10 years, I want to say, setting aside a couple of URUs that have unique features, that the preferred course would be a drilling and spacing unit, right? Looking into the future, if there was some sort of technology change or something along those lines that increased flexibility or oversight was appropriate, I think staff would bring that to you as we think appropriate. I think the things that are important with the URUs that remain in place and have a well drilled has to do with mineral owner recovery and making sure that it continues to be conducted in a way that's fair to everybody within the unit. So answering the question of whether to dissolve this and create it as a DSU is a little bit more complicated. Dissolve existing ones and create them as a DSU is a little bit more complicated, and probably would need, again, that kind of case-by-case analysis. But generally speaking, staff hasn't seen a need for kind of this unique downhole spacing, given the tools that are available and as the Act has evolved in the last decade as well.
Okay, thank you.
Thank you, Ms. Stanzik. Thank you, Director Murphy. Are there other questions from commissioners? Okay, seeing none, I think we will proceed down our agenda to hear the yearly update from Great Western Operating Company concerning its URU, which was created under order number 535827. And Commissioner AAG Davenport, I'm guessing from what we just heard, we hear the report today, and if things appear like they are continuing forward in a positive manner, we would not need to take any action. If we hear and feel there may be concerns, we would then tee it up for a appropriate due process hearing for all parties to be involved. Is that kind of right?
Yes, Mr. Chair, that's accurate.
Okay, with that, it looks like we've got the applicant's attorney with us. If you would like to unmute yourself and start your presentation. Okay, yep, we'll give you a minute. Looks like you need to get your witnesses ready, so that's fine.
Sorry, one second.
There it is.
Can you all hear me?
Yes, we can.
Great, thank you. Just give us 1 minute to make sure we're getting our PowerPoint up. As you can see, we're all in one conference room today. So trying to make this as efficient as possible.
Great, and congratulations that you're all together.
First time, it feels pretty good.
Would it be possible for you to allow us to share our screen? It's not allowing us to show our presentation.
Okay, hearings manager Amaro, if we could give the
So it's David
applicants-
Keehee. There we go.
You should have access now.
Okay, there we go. Okay, you guys see that?
No.
Not yet.
Okay, sometimes it takes a minute.
Share it on another one. Thanks for bearing with us. All right, can you all hear me and see our screen?
Yes and yes.
Wonderful, thank you. Well, I'm just going to start with a quick round of introductions as David is getting our slides up. My name's Kelsey Wazelinski. I'm with Jost Energy Law here on behalf of Great Western. And today you'll hear not only from myself, but from Jason Brand, who's the Director of Exploration, from Kim Sands, who's the Director of Reserves and Planning. And we also have David Keehee with us, who's a landman, and he's available for questions. So next slide, please. So Jane did a great job of explaining what the URU is. I just want to give a little bit more detail about the Pierce Unconventional Resources Unit. As Jane mentioned, it was formed in June of 2017, and that was by order 535-827. It's an approximately 4,800 acre URU. Great Western owns just over 88% of the working interest in the URU, and that's for the Niobrara, Codell, Carlisle, and Greenhorn formations. And also, as Jane mentioned, the order does require annual review by the commission. And I have the language within the order here that the matter is to be set for review by the commission in 1 year and annually thereafter. This is actually our third annual review based on just the timing and when these were set for hearing. Our last one was in February of 2020. So the URU was established obviously by a commission order. And as Jane mentioned, it's a hybrid between a drilling and spacing unit and a state unit. And again, this is probably a restatement of Jane's presentation, but the commission has established URUs to develop deep shale plays in unconventional, meaning horizontal ways. And the commission does recognize URUs as a primary recovery method, not a secondary recovery method requiring ratification from the royalty owners. The Pierce URU is governed by a unit agreement and a unit operating agreement. So those are in place for the URU development. I also want to mention that the URU has been pooled. There are 2 pooling orders for the 4,800 acre unit. And there were statements of support. I don't see them in your portfolio, but perhaps we can double check that. The 2 largest working interest owners within the URU, other than Great Western, did submit Rule 512 statements of support, and that was from Occidental and Edge Energy. So if you combine Occidental, Edge, and Great Western's interest, that's about 98% of the working interest within the URU. And as of today, Great Western has not received any statement of concern from any other mineral owner about its development within the unit. I also want to mention that the URU order does state that the appropriate number of wells be authorized to efficiently and effectively drain the reservoir. And it also limits the number of pads to no more than 6 well pads within or adjacent to the unit to develop the 4,800 acre unit. Next slide, please. So I'm going to show you just 2 maps before we get into Jason and Kim's presentation. This is a satellite overview of the URU itself. The next slide I'll show will have the satellite layer off, so it'll be a little bit easier to see the wells and the pad locations. You could see here 2 wells have been drilled. So the second one was more recent and not included in Jane's presentation, but we do have 2 drilled and producing wells within the URU lands. These are on the left side of the URU in blue. There is a TNM well on the northern edge that's an east-west well. That was actually drilled prior to the URU being established. And it did provide some good production results to Great Western about how to potentially develop the URU. There are 2 approved pads that are used to develop portions of this acreage. And then the circle on the upper left corner is the Rimrock Pierce Gas Processing Plant, which did go online in September of 2019. And I also want to point out the town of Pierce, which is highlighted in purple in the middle of the URU. Just for some context, the Riemann pad, which is the upper leftmost pad, that is about 7,625 feet away from the edge of the town of Pierce. The TNM pad, which is just to the right, is about 5,120 feet away from the town of Pierce. And then those 2 pads are about 2,750 feet apart. So that just gives you some context of the sizing of this map. Next slide, please. This is the same map, but it just takes the satellite overview off or overlay off. Kim and Jason are going to go into much more detail, but again, you could see the 2 drilled wells. The sticks that are kind of a lighter green are Great Western's planned development within the URU. You can see the 2 green pads. The Riemann pad on the left also is developing a spaced unit to the north of the URU, so it is a shared consolidated location. Again, the URU is outlined in red. So with that, I am going to turn it over to Jason to provide an overview of the geology and development of the URU.
Good morning. So this is a map that shows the subsea depth map of the top of the Niobrara Formation. And this map represents about 250 feet of total vertical growth on the upthrown fault block that represents the bulk of the DSU or the URU. And it's that fault block that kind of sets up the unique geological environment that we believe needs to be developed specifically within the URU that we have established through the drilling of the original TNM well to the north. We've established the north-south wellbore orientation is the preferred orientation to drain this structure. And this pop-up structure that's encased within the URU grew up after the deposition of the Niobrara Formation. So we believe that caused unique fracturing within the upthrown fault block. And we've tried to contain that within the URU here. And this has been backed up through the development of the north-south horizontal well that has shown considerably better production than the east-west original wellbore. The URU geometry has been laid out consistent with the structure and with the modern drilling and completion capabilities. And I think that might be all I have to say on this slide. And with that, I'll introduce Kim Sands to you.
Good morning. I'll run through a quick timeline of the URU. So as Kelsey said, we spud our first URU well in April of 2019, and that was in anticipation of the Rimrock plant coming online to provide gas takeaway in the area. We completed the TNM 33-173HC in July of 2019, and this well is currently paying production proceeds to all mineral owners. This well has also helped us understand the preferred orientation in the URU area and lay out our development plan, which I'll touch on in the next slide. In July of 2020, Weld County approved the WOGLA for the Riemann pad. This is our second pad to access the URU. The Riemann Form 2A was approved in January of 2021. And we recently just finished drilling the Riemann 33074HC well, and it's scheduled for completion in September. And as I mentioned before, the Rimrock gas processing and gathering system came online in September of 2019. Before the Rimrock plant, there wasn't very many gas takeaway options up in this area, and now it provides gas takeaway for the URU. Next slide, please. As Jason mentioned, due to the unique geology which underlies the URU, we identified the preferred wellbore orientation in the fault block. Our first well in the Pierce area was drilled in west to east orientation. That's the well that you can see up on the top of the map on the north side. That well was drilled prior to forming the URU. Our first well into the URU, the 33174HC, was drilled north-south. We compared the cumulative production between these two wells at 3 months, 6 months, and 12 months on a barrel per foot basis. We normalized the production because, as you can see, the well on the north side of the URU was only 1 mile long, while the new T&M well is about 2.5 miles long. And you can see from the table below, I won't read the numbers out, but the north-south well has outperformed the west to east well and all 3 measurements of the different cumulative productions. So we've decided to lay out our development plan with the preferred orientation of north-south. Next slide, please. The map on the left shows the proposed development plan, as you saw earlier, with the north-south preferred orientation. The full development will include 45 to 60 wells inside the URU. As Kelsey mentioned, the URU order allows up to 6 pads within or adjacent to the URU. GWP will file up to 4 more Form 2As as OGDPs, and we'll also file the corresponding WOGLA permits. The additional 2A filings will adhere to the new OGDP requirements. Great Western will also permit an additional 11 wells from the Riemann pad to access the URU. As Kelsey mentioned, the Riemann pad also accesses a DSU to the north, so we'll have additional 13 wells going north. And then we plan to permit an additional 13 wells from the T&M pad. And next slide, please.
Great.
Oh, go ahead, Kelsey. I was gonna say, we appreciate your time to provide an update on the URU and welcome any questions. Thank you.
Thanks, Kim. Yeah, we ran through that much quicker than 30 minutes. And so we do welcome your questions, and we've got the 4 of us here and happy to answer questions you have.
Thank you for that presentation. So I guess just kind of the general question, as we were just taught by Ms. Stanzik, issues may arise with regard to an URU relevant to other mineral owners that are not your client having concerns, but it sounds like that you had 5-10 support, that 98% of the mineral interest owners were comfortable with the granting of the URU. Does that remain the case? Are there any mineral interest owners that have concerns relevant to not developing, relevant to being held by production, et cetera?
Thank you for that. And I'll take that unless anyone wants to chime in here. That's correct. So there are 2 Rule 512 statements that should be in your portfolio, and we'll double check that, from Edge Energy and Occidental. And combining those 2 working interests with Great Western's, that's 98% of the leasehold interest within the URU indicating support. And to date, Great Western has received no negative comments, concerns, or feedback from any remaining mineral owner about the continued development of the URU.
Great. Other commissioners with questions concerning the presentation? Commissioner Gonzalez.
Thank you, Mr. Chair. And thank you to all the presenters and witnesses. Appreciate that. I had a question. I'm not sure if I caught this in the presentation, so I apologize if it's a repeat of something you've already said, but is the new Riemann pad as identified here on the slides the same as the Riemann pad from which the Riemann 33-074HC was drilled?
Yes, that's the same.
Okay, so it's the same pad.
Yes.
What are the plans? So it looks like, and I'm going to put on my junior woodchuck geologist hat here. This big structural change that kind of cuts off the URU to the southeast. And if you're looking at the planned wells, you see the ones that are running from east to west. down in the south, I'm assuming east to west based on how those toes go up to that structure. Is that, where are you guys at with the planning and the development of that southeastern portion of the URU?
So this is Jason Brand again. So we have laid that out as best as we can to develop the reserves within the URU. And there's really not an option that you can do down there in a north-south orientation. We think that if we go east-west on that little portion of the block and put a certain type of completion design on it, that we'll be able to make economic well bores down there. That is probably, we will develop that area of the URU later in the development process, so we can kind of basically learn as much as possible on the top side before we move down there.
And just based on what you know now, and I'm not trying to force a crystal ball on you, but what does later in the development process mean? What does that look like? Is that 5 years from now? Is that 10 years from now? Where are we at with that area?
I am not really sure exactly what that timing will end up looking like, but it obviously commodity prices and those types of things play into that. But I think, the company basically plans most of this stuff around a 5 to 10 year development plan, probably closer to that 5 year.
Okay, thank you.
And just to touch on that fault in the east to west orientation just a little more, we do see across the basin, and if you zoom out and look at the basin in the bigger picture, this southwest to northeast trending fault that cuts through the URU, we do see an orientation, a preferred orientation difference across that fault that we think may give those east-west wellbores a better chance of success.
Great, thank you for that answer. Commissioner Messner?
Thank you, Mr. Chair, and thank you for the presentation. I thought that was good and thorough, and it is good to understand the percentage of mineral owners that are in support of this, and to me, that's very compelling. I did have a question on the second to last slide. There was I understand the 2 well pads that are in green on this one, but at least it appears that there's another well pad that may or may not be utilized to access minerals within the Uru. And I guess this is just a question, if that is a well pad and if it's not accessing minerals from the Uru, is it still counted as one of the 6 allowed well pads within the Uru or adjacent to the Uru?
Commissioner Messner, I'm assuming you're talking about looks like there's a bunch of, or several wells that are coming off on the east side of the pad.
Correct.
That's a separate operator, so that would not be part of the 6 pads that are included in the URU.
Okay, that was my question. Thank you.
Other questions from commissioners with regard to the update? Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation. Can you go back to, I think it's the first slide? So if I'm understanding correctly, are you all drilling in multiple formations within the Uru?
It was yeah, thank you, Commissioner. It was established for 4 formations, which we are outside of the greater Wattenberg area, which means that these are not common source formations. So the URU was established for Niobrara, Codell, Carlisle, and Greenhorn. And I'll let Jason fill me in if he needs to, but yes, the anticipated wells will produce in these 4 formations.
And so, sorry, go ahead.
Oh, I was just going to add that, if you go to that development plan map that shows the sticks, the next one down might be half of those well bores that you see are basically planned for the Niobrara formation.
Okay, thank you.
Any further questions? All right. Thank you very much to Great Western and its council for the presentation and the update. We will acknowledge receipt of it and you will proceed forward, and good luck with moving forward with OGDPs, et cetera, with regard to development of the URU or the URU.
Thank you very much.
Thank you.
Thank you.
Okay. With that, we are a little ahead of schedule. It is 11:06. Under our schedule, we were trying to get to noon to keep a lunch break, but we do have PDC Energy and an update that is available. I believe it would be appropriate to take about a 10-minute break, and then we could hear from PDC and remain ahead of schedule. So why don't we do that? Let's break until 11:16. And during that break, if hearings manager Larson and Namaro could get PDC up to the panelists, then we'll be ready to hear from them at 11:16. It is 11:16, so we will start back up. And I do see some representatives from PDC as well as Mr. Lepore. Mr. Lepore, do you have your folks ready to go? Did we give you enough time to get ready?
I believe so, Mr. Chair. I see everybody's name. Don't see everyone's picture yet, but I'm going to assume they can turn on their video when they want to, as well as their audio. So I think we're set.
Excellent. And I see 1, 2, 3, 4, 5 commissioners are present yet again. So the floor is yours. We look forward to hearing from you.
Thank you very much, Mr. Chairman. Good morning, still, commissioners. My name is Matt Lepore. I'm the founder and principal of Insight Energy Law. I am co-counsel along with Joe Prashala of Wellborn, Sullivan, Meck, and Tooley for PDC with respect to their application for a comprehensive area plan. Blessedly, I think the lawyers are done talking now, and we are going to hand this off. Yes, round of applause. I am going to hand this off to PDC's Planning and Development Manager, Dana Strunk. You have heard from Ms. Strunk before, and I know she and her team are very excited to be here today and fill you in on the latest happenings with their CAP application. Ms. Strunk.
Thank you, Matt, and good morning, commissioners. I do have a slideshow that I will attempt to share at this point. So let me get that queued up. Are you able to see that?
We can.
All right. So thank you for your time today. Again, my name is Dana Strunk. I'm the Planning and Development Manager for PDC's Wattenberg asset. I gave the original comprehensive area plan update at the end of May, just after the stay was approved, and I'm excited to be back again for this update. This time I brought along a slide deck and a few subject matter experts that will talk through their sections and be available to answer any questions you may have. So interrupt at any time if you have a question or need more clarification. You're first going to hear from Wes Ensign. He's our senior asset planner. He'll review the CAP development plans, and then he'll hand it off to Brian DeRose, who is our senior land manager, who will give details on our surface locations and local government interactions. Next, Brian Cochier, our senior asset engineer, will discuss infrastructure planning and cumulative impacts. And finally, Courtney Loper, the Director of Stakeholder Relations, is here to outline the goals of our community outreach program. Before I hand it over to Wes, I thought that a quick overview of PDC's operations might be helpful. So we are a Colorado company with about 450 employees between our headquarters in downtown Denver and our Wattenberg field office in Evans. We are one of the largest producers in the DJ Basin with 2,800 active wells and current operations of 1 drilling rig and 1 completion crew. The map on the right here outlines our acreage position in yellow. In the Wattenberg field, we have around 180,000 contiguous acres located entirely in Weld County. This map outlines 3 projects in our 4 main geographic areas that we're working on this year. We submitted this Spinney OGDP in May and are currently working through completeness on that one. Our second submittal will be the Kenosha OGDP, which we anticipate submitting in the 3rd quarter of this year. And then you'll see the outline of the Guanella CAP, which is what we're here to discuss today. So with that, I will hand it off to Wes.
Great, thanks, Dana. Good morning, commissioners. Appreciate the time. So what I want to do here is give you a high-level overview of the Guanella CAP and what we've designed so far. So the Guanella CAP, just to rewind just a little bit, as you heard in the stay hearing, is named after the Guanella Pass. Rationale behind this was that many of the pads within the CAP development are named after mountain peaks and Colorado 14ers. So we thought that it was appropriate and fitting that we would name it after a pass that's actually pretty popular. So the CAP is in and of itself is going to be a little bit more than 32,000 acres or 51 square miles. The entire CAP is within Weld County. And something that we're really proud of here at PDC is that we'll have a greater than 90% working interest in the acreage. And every unit within the CAP in and of itself will be above the 46% pooling threshold. So as of today, we anticipate that the cap will have 25 surface locations and 457 wells within it. With that, we methodically laid out the development plan based on the fluid types and the lateral lengths that we would be able to achieve. And this will allow us to drill up to 16 wells per section in the gassier acreage and up to 24 wells per section in the acreage with a bit more oil. And then if you move into the timing portion of this, the expected timing and duration of the cap, once it's approved, will begin the initial phase, which will involve the build out of our infrastructure. We do anticipate that will take 2 to 3 years. And we'll have a little bit more detail around that in the coming slides, as Dana mentioned, that Brian will go over. But once we've established the infrastructure, we do anticipate that we'll begin drilling in 2024 with about 6 to 10 years of activity, depending on the drilling and completions pace. And then with that said, we expect that we will be requesting a 10-year expiration for the cap. And we're doing this so that we can properly build out the infrastructure and so that we can work with all of the other parties to make sure that the infrastructure is lined out the right way from the very beginning. So unless there's any questions, I'm going to pass it over to Brian DeRose so he can discuss more details around our surface locations.
Mr. Ensign, if I could, and as we go, if we can ask questions, but can you talk a little bit about the infrastructure that is planned? You say you've got 2 years to sort of develop that out. What are we talking about?
So there's kind of a litany of things that we're going to be working through from the infrastructure side. And like I said, Brian Cosier will go over a little bit more of the details on that, but we are referring to pipelines so we have oil and water takeaway. We're talking about electrification of the field. So we're trying to partner with some of the electric companies to make sure that we can get electric to all these locations. And so what we have learned is that it does take a little bit more time for those companies to plan based off of our plan. So we have to give them a little bit more, I guess, forward planning opportunities or so that they can actually see where we're headed and start building out their infrastructure to meet our infrastructure.
And just a follow-up question, but does the comprehensive area plan approach sort of this concept, does it provide the opportunities for this comprehensive infrastructure development as opposed to, doing an OGD over here versus an OGD over here?
Absolutely, it does. One of the main advantages that we've noticed with the comprehensive area plan concept in and of itself is that it gives us an opportunity to come to these other companies and tell them where we're going to be, and they can build certainty around that. Whereas with certain OGDPs kind of being sporadic throughout the field, it makes it difficult for them to be able to get there for one-off locations. So they feel more confident in our plan. So they feel more confident spending the capital to get there.
Excellent. Thank you for that clarification, edification. We really appreciate that information. And now I think we'll look forward to hearing from Mr. DeRose.
Thank you.
Thank you. Can you guys hear me okay?
We can.
Thank you. Good afternoon, commissioners. As Wes mentioned, there are 25 locations within PDC's 32,000 acre cap. Of these 25 locations, and to date, we've reviewed and evaluated just over 100 locations through the lens of the COGCC mission chains, and specifically the alternate location and analysis portion. Key identifiers in the evaluation process have been building units, waterways, wildlife, existing and future infrastructure, and surface consolidations, just to name a few. In this last year, we spent a great deal of time not only evaluating this area for locations, but really making each location and pad harmonize together by looking at the surface from a holistic approach across the cap. To that end, PDC has been successful in executing 18 of the 23 surface use agreements needed and looks to close out the remaining 5 here in the near future. In addition to our evaluation process regarding alternate locations, internally, we've been really tightening the screws throughout each discipline to design a unique pad for each of the 25 locations that best suits the community and landscape. It's not a one size fits all. The locations range anywhere from 8 to 38 wells per pad, with majority of them yielding about 24 wells per pad. We can expect to see about an average size, an average pad size of an approximately 12 to 15 acres during the development phases, and then subsequently reduced to 3 to 4 acres during the production phases. We're able to accomplish this by reduction by designing our facilities and working with our industry partners to have oil, gas, and produced water takeaway via pipeline. Throughout the landscape of the CAB, there are 5 municipalities, all of which are located in Weld County. And you'll note on the slide presented, Greeley, Evans, Milliken, LaSalle, and Gilchrist, each one represented in a different color depicting its boundaries. Of the 25 locations, 2 have been identified within Greeley's municipal boundaries and 1 that's located in Evans, each of which have provided letters of support. The remaining 22 locations are in unincorporated Weld County. As Dana mentioned in late May, we've met with all proximate local governments, not only to ensure they're fully informed, but for feedback and to further understand the future build-outs and timing within their communities. One example I'd like to provide is our bypass pad, which is on the northern end of our CAP located in Greeley. This pad is proposed to develop approximately 1,120 mineral acres, in turn allowing PDC to plug and reclaim up to approximately 22 vertical wells within the area. With thoughtful planning with the city of Greeley, Greeley will be able to take advantage and time their build out of the area, paving the way for more commercial and residential development. This broad level planning has been welcomed by each local government and helped PDC put an emphasis on the holistic approach to the Guanella CAP. With that, I can turn it over to Brian if there's no further questions for me.
Any questions from commissioners? All right, Mr. Koshier, I believe you're up.
Well, thank you, commissioners. Thank you, Brian. One of the major benefits of the systematic development plan being outlined by the CAP is the ability to work with these outside entities on the planning of infrastructure buildouts to avoid and minimize potential impacts. There are 2 critical components needed to create beneficial plans: siting and development timing. This is particularly true for developments that are 6 to 8 years out. Fortunately, Rule 314 contemplated the importance of this with the ability to receive preliminary siting approval in requiring a development timeline. Without these components, I don't believe we'd be able to present to you today the work that has been done with our midstream and utility companies that will greatly eliminate or reduce some of the potential impacts of this development. PDC has 3 entities providing midstream takeaway over the lands of the Guanella CAP: DCP, Chevron, and Black Diamond. We've been working with each company for months, forecasting the timing of the development and projected produced oil, gas, and water volumes from the 25 proposed locations. In addition, we have accounted for volumes outside of the CAP development in order to better understand needed infrastructure build-outs to process the increased volumes in relation to current capacities of today and in the future. Based on the ongoing collaboration, all produced oil and gas will be piped off CAP locations. For water, we are working to achieve our goal of having the majority of our locations have water piped off as well. In the past, produced water was generally trucked off location in the basin, so the pipeline infrastructure is less developed or less mature. We are continuing to understand these constraints and working to overcome them. Finally, we are confident and committed that all water needed to our locations for completions operations will be conveyed without the use of trucks. Similar to midstream takeaway, we've been working with our electrical utility providers on understanding the capabilities of electrifying our operations utilizing grid power. Both Excel and PVREA have coverage areas of the lands of the CAP. It has also been an iterative process with each entity in which we initially started with preliminary locations and timing of development based on the operational phases of drilling through production to understand the proximity to infrastructure. We have progressively sharpened the pencil, aligning our development timings with the ability to provide line power to our locations. Through the iterations, we currently have been reviewing PDC's peak demands by month for each location, stacked over time for drilling and production, and then based on geographic area. Due to the continued work of our surface land team and the ALA process, we have continued to refine these peak loads as locations have consolidated, which has also shifted timing a little bit. At this point, we are now working through the needed infrastructure build-outs and associated costs with each entity. But we are confident to commit that all drilling operations and production facilities will be fully electrified within this CAP development project. As we finalize the work over these next few months, the infrastructure plan submitted with the CAP will fully illustrate the commitment of PDC to eliminate or reduce potential impacts through thoughtful infrastructure planning. I guess I'll stop here if there's any questions on the infrastructure to go to the next slide.
Yeah, just kind of a follow-up to the same question I asked your colleague earlier, but it appears that the CAP is giving your company this ability to plan ahead and get the infrastructure in place. And I think I just heard you say that with regard to the pipelines that you are contemplating not just piping the mineral from the CAP, but perhaps areas nearby. Did I hear that correctly?
Yes, yeah, in working with the CAP, we also need to contemplate, future or existing development outside of it. So with that, we're projecting, mineral volumes and water volumes in some cases from outside to integrate into the capacities of the infrastructure build out for the CAP.
That's excellent. So it really is giving the company the ability to create this infrastructure that is much more protective than sort of one-off development, it sounds like.
Yes, sir. And Chair, just to kind of follow up to the question you asked previously to Wes, in sitting down with these companies and reviewing our projected development and being able to provide peak loads by month, for drilling completions, the commentary was, this is exactly what we need in order to feel confidence to build out the infrastructure. Meaning, we have proposed locations so we can better fit it within our capabilities, but also planning, for the loads that are needed in conjunction with future development within these communities. So this style of planning fits very well in being able to provide, such a detailed and committed infrastructure plan. And it was noted by the entities that we're working with.
And just a follow-up comment, but in a previous life that I lived as an attorney for local governments, I worked on operator agreements, memorandums of understanding, and one of the things that my local government clients wanted back in the day was electrification, and we weren't able to negotiate that. And I just informed my fellow commissioners the problem was that we were looking at one well, one location, and the utilities did not have the ability or capacity to bring in electrification on a one well or one location approach. So I'm pleased to see how this is, I think, mirroring what we were hoping to see as we discussed and thought about the comprehensive area plan approach to development. So thank you for that additional information on that front. Do other commissioners have questions or comments before we move on to the Commissioner Messner?
Thank you, Mr. Chair. And I've got 100 different questions, but I want to be a little careful, I guess. And I've got a question just on process. Because my understanding is that these updates are really to understand the progress of the application as part of a condition of approval for the stay. And so I guess a question to AAG Davenport is, I'm assuming we certainly don't want to get into the merits of the application, understanding that we will be reviewing this application at some point in the future. Is that correct?
AG Davenport.
Thank you, Mr. Chair. Thank you, Commissioner Gonzalez, for the question. I think that's generally correct. I mean, I would say asking questions about the progress and what the plans are is appropriate for this update. Obviously, the application hasn't been filed yet, so there could be differences or changes in that point in time. So I would recommend that the commission, reserve actually consideration of whether or not to approve the application until the hearing on the application itself.
Sure, but and I appreciate that. So, okay to ask some questions about details of the potential application, or stay clear of that?
I think you can ask questions about the plans right now for the application and understand the progress that's being made, which goes directly to the stay and the condition for continuing to keep the stay in place.
Okay, thank you for that. I don't have any questions right now, but I just wanted to make sure that my questions were going to be appropriate. Thanks.
Other questions from commissioners? Okay, are we moving to Ms. Loper next?
No, I'll keep on going.
Okay.
Just to the next slide here. So as the infrastructure plan aims at reducing impacts, the cumulative impact analysis will evaluate them. As with many instances post January 15th, we have all been navigating in new waters. And when it came to the cumulative impacts, we wanted to be sure that we contemplated for everything possible. For this, PDC has partnered with Kleinfelder. Kleinfelder brings over 20 years of experience in preparing NEPA documents for oil and gas development on federal lands, as well as regulatory compliance in Colorado. We started this endeavor with Kleinfelder in developing the Form 2B for a single location OGDP, the SPINNY that was on the slide previous. We learned a lot from this, but started thinking of how it applies to a development of the magnitude of the CAP. The data is of the utmost importance, but we wanted to ensure the final product is consumable by all audiences, ranging from the technical staffs of COGCC and CDPHE, the CIDR database, the commissioners, and even the general public. So we have spent a lot of time to thoughtfully think of the final product, and we'll develop a holistic analysis to provide a robust, comprehensive evaluation at the CAP level, but based on the data of the individual locations provided within the Form 2B and ALA. We are well underway in developing the cumulative impacts analysis. Currently, we're performing an environmental assessment over the lands, including wildlife, ecosystems, and soil resources. In addition, we are building out the emissions inventory. Most importantly, though, we want to have the ability to quantify the emissions reduction of our electrification efforts from the baseline of diesel-powered operations. We have also conducted preliminary consultations with CPW in order to identify, protect, and preserve sensitive habitats and species within the CAP. As outlined by Brian, our approach is to consult early and often with local governments, regulatory bodies, and the communities. Within the CI analysis, there will be a mitigation toolbox to further illustrate our ability to eliminate and reduce potential impacts. However, it is important that we don't cement ourselves in time based on currently available technologies. In that, as technologies evolve, we want to have the flexibility to adapt to increase protections based on the BNPs of what's currently available. And finally, PDC has had the ability to evaluate the wells that will be fully plugged, abandoned, and reclaimed due to this development. It is important that in most cases, these are vertical wells, which represent individual locations. So through this analysis, PDC will be able to remove up to 640 existing wells. What that means for land use dedicated to oil and gas in these lands is a net back of approximately 1 square mile of land back to the communities and landowners. And when I say net back, that means the total lands given back from the plug and reclaims are a square mile over what our development during interim reclamation will be. So in many cases, what that means is that these communities that grew up around existing oil and gas infrastructure, the wells removed are the ones that are potentially the most impactful. And with that, if there's any questions on the cumulative impacts, I'd be happy to take them. And the map that you see on the right of that presentation there, that is the map representing the existing wells that'll be removed.
Okay, looking to fellow commissioners. So I guess one question in that we're getting kind of an update bi-monthly. Are you timely in terms of the additional work that's happened over the course of the last, say, since we heard this last month or 2 months ago? I mean, are you feeling like that you're making the progress to get to a point of getting the application filed? I think you mentioned within 6 months of the variance or thereabouts.
Q4 is our goal for full submittal. So since the last update, we've been developing the framework of how we'd like the cumulative impact analysis to look. Like I said, we want it to be consumable or readable by all audiences so that the adverse but beneficial impacts of this development can be realized. So with that, we've met with staff 2 weeks ago to present on what our vision of this cumulative impacts analysis over the CAP lands will be. We're talking something 60 to 85 pages, but based on data. So, we're working with staff and making sure that everything is contemplated to get to completeness. So with that, now we're in full mode of compiling the data and doing the evaluation. So, the goal is to be done with the evaluation within the next 2 to 3 months.
Thank you. Other questions for Mr. Coshier? Okay, seeing none, who's next?
All on me. Commissioners, thank you for your time today. We'll pivot to talk about community and communications. For PDC, we know that community relations, community engagement is critical to our success. And really that includes both the legacy communities that we've had relationships with for years, and those with whom we'll strengthen relationships as we move through this CAP process. And as we've said before in these updates, no two communities are the same. No two families are the same. No two individuals are the same. And recognizing that fact and the fact that some of these communities are disproportionately impacted by the oil and gas development process means that we really look closely at how best to interface. And while the required census information, income and language, for example, is helpful, it really gives us an incomplete picture. It limits our perspective to put people into boxes based on just two or three criteria. And so to achieve a more holistic view of this, what PDC has done is pioneered a first of its kind dashboard that takes a deeper dive into this census data. We really see this as first in class and best in class. And to know how best to reach a community, we need to understand things like if they have access to the internet, how do we best reach them? A website or an online hub might not be the right answer for everyone. Access to vehicles, will they need transportation? Are there walkable locations where we could hold events? Education level, how do we craft our documents so that they're easy to understand? Do folks work conventional 9-to-5 jobs or alternate hours? Home ownerships, really this is logistical. Will public records have the right residents listed for us? Children in the household, will available hours be impacted for community meetings, or will we need to provide childcare? And while this list still doesn't tell us everything, this data-driven approach really gives us a greater understanding of how best to stimulate that two-way communication. And we're really proud of what we've created and the way that we're going to be able to use this to develop our plan moving forward. And I'm going to go to the next slide and then take questions because the two dovetail together. So Dana, if you could switch. So when we say two-way communication, we mean it. We don't want to talk at the communities in our CAP. We want to listen to them. And we know that folks may have some great ideas that we have not even considered. And so we plan to document all of these as we move through our various communications platforms and communications opportunities, and to document this and to see what may be feasible and applicable and able to be included in our operational plans. we've hired a consultant to support us in our efforts because we know that the more expertise and the more bandwidth we have engaged, the better. And as Brian said earlier, we've already had meetings with local officials and surface landowners, all of which have been supportive and encouraging of PDC continuing to move through this process. There are also several things in the upcoming category, as I'll put it. We have a dedicated microsite ready to go when the time is right. And that's where folks can see answers to common questions about our CAP, learn more about PDC, and most importantly, find a phone line that's going to be staffed so that they can get on the spot responses. Your answer, or if your question isn't on the website, we're going to get you one. And in the meantime, we're going to be out in these communities this summer. Obviously, we can't formally, execute a lot of this plan until our completeness determination, but that doesn't stop us from engaging. Community relations and community engagement is a big part of who we are regardless. So we'll be out at events throughout Weld County this summer. I know that I've listed quite a few things, but to sort of summarize, we really believe that our DI dashboard, our communications platforms, our current community engagement, topped with that close communication with the local elected officials who really know their communities better than anyone, for us represents a best-in-class engagement program. So with that, I will take any questions that you have around this.
Great, thank you for that update. Questions from commissioners? I see Commissioner McGowan.
Thank you, Mr. Chair. And I realize there's maybe a chicken and egg kind of situation going on here, given that we don't have any formal approval for what you're trying to do. But I also hope that as you're developing your alternative location analysis and trying to determine where things exist, that you're including community in that discussion, not just local governments. And so I know that like what comes before what, just having a community meeting and saying, here's what we're going to do, we're informing you, is I think not quite what we had in mind as a commission. So I hope that you all are thinking about what that will look like.
Absolutely. So our goal when we look at development is to minimize the impact on any community, disproportionately impacted or otherwise. So when we're thinking about what that looks like, we are making sure that when we're looking at locations, we're as far away from any BUs as we can. On the communications side of things, these are all communities that we're very familiar with. And so we have pretty consistent engagement with these. And I know that it's not specifically in the CAP, but I'll give you an example. For our Kenosha OGDP, which you have not yet seen, we just held a community meeting last week. So we wanted to make sure that prior to that process, that we had the opportunity for folks to come to speak with us, to ask questions. We offered an opportunity for them to speak to subject matter experts from each of the areas of our company. So yes, very much so, that is part of our process and that is part of our plan. And you're right, there is a chicken and egg component to it, but we're certainly not going to sit idly by and then hope that people agree to, like, welcome, etc., the things that we put before them.
Great, thank you for that response. Other questions from commissioners? Okay, I'm not seeing further questions. Purpose of the presentation was to provide an update. I think we.
So Chair Robbins, sorry to interrupt. We do have one last slide, and I just wanted to make sure we showed it because this was actually a request from Commissioner Gonzalez during the stay hearing.
Great.
This shows a few of the metrics and some progress through the CAP. So it was asked to do some sort of progress report. So the intention will be to show this same slide during each of our bi-monthly updates, so we can easily follow the progress in each of the categories that we discussed today. So below each of the category names, there's a shaded circle that represents the % complete. And below that are sections that list the major tasks that have been completed and the remaining work to be done, which you heard in the previous slide. So I don't have to go through each of those bullet points. But I've already heard today, and as you can see in the % complete, there's a lot of work that has already been done to date. And this work did not start at the granting of the stay at the end of May. In fact, we've been working on the development plans for this acreage since we acquired it from SRC in the beginning of 2020, and SRC had been working on that before the merger. The first key step was to get the development plan to a point where we were confident in the boundary and the surface locations, because those two items were key in starting the major work in the other categories. We're now executing the final SUAs and doing survey work for the detailed submittal on the development plan. The infrastructure plan and community outreach plan are more than halfway complete. And with the scoping work behind us, we can now dive into the detailed work on both of those plans. And then the community impact study is also underway and will be progressing quickly. So as Brian said, we feel we're on track to submit this CAP in the fourth quarter of this year. And if you think about that in terms of these bi-monthly updates, we'll be showing more progress in our update in September. Then hopefully by the time of the following update, which would be in November, we'd be presenting a completed plan that is either very close or already officially submitted. That's all I have in terms of formal content. We can now take some general questions on that, or the CAP in general. Thanks.
Commissioner Messner has a question.
Thank you, Mr. Chair, and thank you for the progress report. This is good information. I've got a few questions just about kind of how it's working, how it's going, how the process is unfolding, and as you guys in many ways are the guinea pig in implementing a CAP. And kind of the philosophically, as you were approaching this CAP, and understanding there was a need to do consultations with local governments and disproportionately impacted communities and CPW and water professionals or water districts, so on and so forth. Did you make all those consultations initially kind of holistically through the entire CAP area, and then utilized information from that to start whittling down through ALA process which sites would be most appropriate within the CAP? Or was it these sites make the most sense from a geology perspective or a resource access perspective, and then tried to figure out where in this particular area you would try to figure out a site that may work with consultation?
Yep, I can take the first and then hand it off to Wes. But to me, that's a great question. And I think if you look at the details in each of these slides, it seems a little bit overwhelming at first. But what I would say is that this is what PDC strives to do in any of our areas. And this one in particular, as we came through the SRC merger, it was very obvious that this area could benefit from a larger infrastructure plan, both on the pipeline side and the electrification side, because there was not a lot of recent activity. There was a lot of old oil and gas activity there, and a lot of opportunity for us to come in and be able to lay out something very methodical and comprehensive over the entire area. So I would say when we first started looking at the area, creating that boundary, looking at what the opportunity is to come in and develop that plan in sort of a mowing the lawn approach, where we would be able to come in and drill and complete in a more methodical manner. So I think that was the high level beginning. I don't know, Wes, if you want to add to that.
Yeah, I think it's a great question, and I'm excited that you asked it, because that's the world that I live in. So I think the more important, I guess, point that I want to get across is that when we established the overall boundary of the CAP, it was intended to be as all-inclusive as we could possibly make it, to minimize the overall impact that we would have on the entire acreage position as a whole. So the bigger the project, the more flexible you can be with where you can put your surface locations, how you can develop the acreage, and then how many wells you can drill from one specific location. So the bigger the bigger the area, the less surface disturbance you have, which then also means the less impact you have on the community in that area. And so we were really excited that we had such a contiguous acreage position. So when we saw that we had so much acreage in one consolidated area,
it made sense for us to try and capture as much as possible so that we could be good stewards of this acreage. And so to your question, Commissioner Mesner, there is an element that we look at from a geologic side of things, and where, how would we develop this from a reservoir stewardship side of things. But then at the same time, when we made it as large as we did, it was based around, well, we don't want a boundary that is going to limit us to having to drill in a floodplain or something like that, or right next to a community. So the bigger the boundary, the bigger the opportunity is for us to be as far away from communities as possible. So in some areas, to Dana's point, we always look at it this way. And so we, for the entire acreage position that PDC owns, since I am the planner of that, of this acreage, that's how I always look at the development, is how can we develop this in the most efficient, methodical way possible that is the most advantageous for the community. And so that's what we applied here as well. I hope that answered your question.
No, it did. I really appreciate that, because it is overwhelming to think about how to approach it and how to philosophically look at it and what goes first. It's kind of the chicken and egg thing, like Commissioner McGowan indicated. And so I appreciate that explanation. I think one other question that I had was, certainly and I think it was maybe 604 wells that may be P&A'd as part of this CAP application, and therefore some associated cumulative impacts with those existing wells, would be fairly significant as far as the P&A activities on those. What's the timeline for that kind of P&A activity in relation to the new development?
Thank you, Commissioner Mesner. So, the P&A activity is in, cadence with the development. So as we go through and kind of develop the lands, as Dana said, mowing the lawn or kind of get in and out, those wells will go away with the new development coming in. Because, the acreage position will be held, but also the mineral interest owners will now have, stake in newer wells. Okay. So you remove the existing infrastructure as you come in with the new development.
And so based on the proposed timeline of 10 years, this would all be completed within 10 years of these activities.
But I will say, like Brian DeRose pointed out, in the initial consultations that we have with these communities and developers, there's an understanding of also the growth of their communities. So, we switch our schedule in lockstep with the communities as they try to expand, and that we'll remove wells if there's expansion plans. So it's not just PDC coming in and saying, this is how we're going to develop. It's how does it make sense for the communities and local governments to develop? That's why, we're consulting early and often, and to your prior question, it starts at a holistic level to really, really encompass or grasp the full scale of this. And then you dive into the specific locations. Because if you're looking at the specific locations under a narrow lens, you kind of miss the picture. Essentially, you're not seeing the forest through the trees. So those early consultations help us in developing that development schedule, which allows for those wells to be removed.
Great, thank you. That was helpful.
Just one other question from me. Someone suggested you were guinea pigs, but you are certainly one of our Colorado operators that is using the newly developed comprehensive area plan process. As you're going through this, are you seeing any unintentional hiccups with regard to the rule in terms of development of your application? And again, I sort of say that because we created this wholesale, and I'm interested to know, does the rule meet your vision? Are you seeing issues with regard to things? I mean, obviously it's taking a while to develop up an application, but it's not a bad idea to sort of gut check in terms of what we created in terms of how it's actually using an application.
I can start and then hand it off to anyone else who has comments. For me, in general, the concept of this comprehensive development plan is exactly what we would like to develop using. I like the idea of having that holistic approach to understanding where our service locations are and how that reflects our development plans. So in general, I think this concept is great, and that's why we're pursuing it. I think where the timing is that takes a while is just understanding the details on what needs to be included in the submittal. Just, I think in general, talking about OGDPs and CAPs, just making sure that we're all on the same page with the commission and with the COGCC to make sure that we're providing the information that they need. And getting clarification on whether we can provide, something on that high level holistic approach, or if we need to come in on individual locations and have so much detail on each individual location. We're trying to look at it at a more high level. So trying to balance the high level with the specifics, I think, is something we're really trying to work on at this point.
I assume that you're able to have meetings with staff to sort of thread that needle?
Yes, I believe so. I don't know if anybody have any comments on cadence or any of that.
Yeah, Chair Robbins, to that, to kind of follow up with Dana, that was one of our questions about the cumulative impacts analysis, right? Because you need to have a holistic view of it in order to really understand the benefits of a project of this scale. And like we mentioned before, not really looking at each location under a narrow lens, but still providing that information so it can be contemplated properly. So that was the exact purpose of that meeting we had 2 weeks ago with staff, was to go through that. Kleinfelder came in and presented as well some of their expertise and kind of what they've learned through the NEPA process, and is finding that balance between able to tell the holistic story, but still have the finite detail of the individual location. So I think it's the delineation line between a CAP and an OGDP that we're still working towards understanding. But at the same time, we're all going through this together. We're the guinea pigs, but so is the staff and so is the commission. So we're happy to start this endeavor of something we really believe in.
And Brian, to that point, and Chair Robbins, to your question, I think, to the extent that we're all guinea pigs in this, I think we really do value the ability that the staff has given us to access them, to ask questions. We've had good regular meetings, open communication. So we really do see this as, a process that we're all really, learning and working through together. So I would commend the staff for their engagement thus far.
Great. Well, that's the answer I hoped for, and it's great to hear. And we appreciate the update that you've provided today. I'm looking around at my fellow commissioners to see if there are further questions. Great. Okay. Well, again, thank you for your time today. We will look forward to hearing from you in September, which would be the next bi-monthly update, and then potentially seeing the application in the fourth quarter. So thank you again for all of the presentations. Anything further from your panel?
We appreciate your time as well. Thank you.
Okay. Great. Thank you, everybody. At this time, I believe we have arrived at our 30-minute lunch break. We're about 5 minutes past, so let's take 30 minutes and reconvene at 12:35 for the remainder of our agenda. All right, welcome back, everybody. This is the afternoon session of the July 7th Colorado Oil and Gas Conservation Commission hearing. Our commissioners are present and we will move forward with our docket. Next is a presentation by staff enforcement, Mr. Stephen Kirshner, and will be presenting relevant to the Alta Mesa Services docket number 2012-00279. Mr. Kirshner, the floor is yours.
Thank you, Chair Robbins. I'm going to share my screen here. Okay. Once again, my name is Steve Kirshner. I'm one of our enforcement officers here with Commission staff. Today's staff is before you asking you to approve an order finding violation against Alta Mesa Services LP in docket number 2012-00279. I'm going to briefly go over the background behind this enforcement action. I'll kind of give you a summary of the violations, and then I'll talk to you a little bit about what staff is asking for you in terms of an order today. And if at any time you have any questions, please don't hesitate to ask. I'm available, and also with me are Denise Arthur, who's our reclamation supervisor, and Ryan Costa, who's the inspector, who's done the lion's share of work out there at the site. So, the operator at issue today is Alta Mesa Services LP. Alta Mesa operates one location and one well in the state of Colorado. So there's no more wells or locations to be concerned about with this operator. It's just the one location, the one well. The well at issue here, the Freeman 324, was plugged and abandoned on December 2nd, 2017. That date is, of course, important for the final reclamation discussion that we'll have in a moment. Now, in December of 2018, the Commission approved an AOC between Alta Mesa and Commission staff. That oversight violations related to various things, such as failure to file forms, extensive weeds around the location, stormwater BMP issues, and failure to conduct interim reclamation, which essentially is the requirement to reduce the footprint of the location from what's needed for drilling to only what's needed for ongoing production. Pursuant to that order, about $130,000 of the total penalty would be suspended pending the timely completion of certain corrective actions. Those corrective actions are listed here and listed in the order. Now, staff inspected the location numerous times from 2018 until just about a month and a half ago in May 2021. During those inspections, staff observed that Alta Mesa failed to accomplish any of those corrective actions that we discussed. I'm going to, additionally, while you're looking at the photos, I'd also like to bring you up to speed on Rule 1004A, which governs final reclamation. Essentially, it requires that final reclamation of a location occur within 12 months or 1 year of the well being plugged and abandoned. So if you'll recall, that plug and abandonment date was December 2nd, 2017. So I'm going to show you a series of photos that were taken by Staff Inspector Ryan Costa, who has been out to the site several times over the last several years. And if you have any questions, like I said, Ryan's available. Denise Arthur is also available to discuss. This first photo is facing north towards the location itself. As you can see, the access road hasn't been reclaimed. The cattle guard's still there. The fence is still there. This next one shows the gravel pad, and it also shows that the location itself clearly hasn't been reclaimed. There are noxious weeds throughout the location. Those two red arrows in the photo do indicate noxious and undesirable weeds. This is another photo that clearly shows the delineation between the gravel pad and the surrounding land. That gravel pad was supposed to have been reclaimed. Clearly it's not. You can also see from the slope here into the gravel pad that the location hasn't been recontoured as required. This next one shows weed and debris buildup along the fence line, fairly self-explanatory. And then I wanted to show you just this photo to show you what an undisturbed reference area around the location looks like. So had Alta Mesa successfully completed that final reclamation work, this is essentially what the location would have looked like once it was finally reclaimed. So as you can see, there was an outstanding failure to complete any of those corrective actions pursuant to the order, as well as a failure to do final reclamation on the site. Staff was in contact with Alta Mesa periodically throughout this period, but on June 11th of 2020, we contacted Alta Mesa the last time about the corrective actions, and we didn't receive a reply. So on August 10th, the director issued a written demand letter to Alta Mesa pursuant to the order for that suspended penalty amount that we discussed earlier. The director didn't receive a reply there either. And the reason that the director didn't receive a reply is that on September 11th of 2019, Alta Mesa filed for Chapter 11 bankruptcy relief in Texas. Now, neither the commission nor the AG's office received any actual notice of the case in time to participate. On May 27th of 2020, the court confirmed Alta Mesa's plan. So in that plan, none of the assets at issue here were sold or liquidated or transferred. Essentially, we've discussed this before in PetroShare, but essentially those assets remained in the hands of what is more or less a shell and doesn't really exist anymore. Under Alta Mesa's bankruptcy plan, there was no material distribution of assets made to the unsecured creditor class of which we would likely be a member. It's also important to note here that under the plan, no further assets of Alta Mesa remain for the commission to pursue, and even if they did, the plan would prohibit the commission from pursuing those assets. This bankruptcy information comes from consultation with our bankruptcy counsel at the AG's office. Obviously, once we did learn of the bankruptcy, we worked with them to try and determine what our position is. And we determined that essentially we hadn't received notice and we were not in a position to participate in any meaningful way. And like I said, even if we did, the plan would prohibit us from pursuing any of the assets. So as such, we proceeded to kind of take the only venue left to us, which was enforcement proceedings. So in November 2020, we issued an NOAV for violations of Rules 522F and 1004A. Rule 522F essentially is a violation of the previous order, and Rule 1004A, as we discussed earlier, governs final reclamation. On November 16th of 2020, service of that initial service of the NOAV was perfected by certified mail. We didn't receive a reply because Alta Mesa essentially doesn't exist anymore. On January 7th of this year, a hearing officer issued an initial notice of hearing. That certified mail was service by that certified mail was perfected in January. We also served it by email to all of Alta Mesa's last known contacts. Soon after that, we determined that there was a publication error with that original notice. So in order to cure that publication error, we asked the hearing officer to issue a second notice of hearing. That was issued in April, and service of that notice was perfected in Alta Mesa in May. That was also again served by email. We've also served the bondholder in this matter. Staff received no reply from Alta Mesa, and publication of this notice was completed in May and June for Denver and for Huerfano County. In May, staff filed a motion with the hearing officer to have this motion heard directly by you, the commission. On June 17th, the hearing officer issued an interim decision granting that motion. On June 23rd, you approved that interim decision and you agreed to hear this matter directly. And on June 29th, Secretary Larson notified us that this matter would be heard today, July 7th. So just to sum up, Alta Mesa has not responded to the NOAV. They've not filed anything in this matter. They haven't objected to any of staff's filings, and they're not before you today. And the reason for that, I know that there was a question about that during the interim decision discussion a couple weeks ago. The reason for that is essentially Alta Mesa doesn't exist anymore. The assets were absorbed by various companies, but none of those companies absorbed these assets. And essentially these Colorado assets remained in the hands of that shell. So there's really no one on the other end of the line at this point. The order that the commission, the staff's asking you to approve today contains two violations. As we discussed earlier, the first one is a violation of Rule 522F, which is for failure to complete the corrective actions required by the order and to pay the suspended penalty amount. The other one is a Rule 1004A, which is failure to complete final reclamation work within 12 months after plugging the well. The penalty for those violations is laid out here. Staff has assessed these violations at a moderate impact. In our opinion, the failure to reclaim a location does carry with it a threat to public health, safety, welfare, and the environment, including wildlife resources, and that describes a moderate impact violation. So that's what we've done here. And that total penalty is $344,140. I should add, once again, there's no expectation on staff's part that this penalty will ever be paid. It is at this point purely a vehicle to claim that bond, which we hope to use to help reclaim that location. So if Alta Mesa fails to comply with the OFE that we've asked you to approve, staff may declare Alta Mesa's well and location orphaned. Staff may claim all the equipment and the saleable product to help us pay the cost of reclaiming the location. If Alta Mesa fails to comply, the director shall, so the director is required to revoke Alta Mesa's authorization to conduct oil and gas operations in the state of Colorado and to foreclose Alta Mesa's financial assurance, which is a total amount at this point of $20,000 in order to help pay the cost of reclaiming the location. So staff today is asking that you approve this proposed order binding violation that you can find in your portfolio. There are two requested changes that I have for you from the order as filed. The first is relatively simple. If you look at the order, there are sections in that order that were highlighted. Those are related to dates and penalty amounts. And the reason for that is because the penalty amounts, the end date of the violation is today's date, the hearing date. And if for some reason that hearing date was postponed or changed, that penalty amount would change. So those spaces have been highlighted. And in a final order that was approved, I would ask that the commission remove those highlights. The other thing that we would ask is that paragraph 17 of the order as proposed be stricken. And the reason for that is that it refers to a requirement that applies only to recommended orders considered by the commission, and it does not apply to orders finding violations. So this order would be final today, essentially, should the commission approve it. It would not have that 20-day period that a recommended order goes through. So, and I'm happy to go through those again, but staff's asking you today to approve the proposed order finding violation with those two suggested changes that I've noted. And with that, I am happy to take any questions that you might have.
Thank you, Mr. Kirshner. I think commissioners do have questions. Commissioner McGowan was first, followed by Nanjapa. I also have questions, so we will take it in order.
Okay.
Thank you, Mr. Chair. Thanks for the summary of the materials that we were looking at earlier. So when you said that, so we don't expect, Alta Mesa is not here, they don't exist anymore, we don't expect that they're going to pay this penalty, it is a vehicle to get the bond, do we have to issue the penalty in order to have access to the bond, or can we skip all of that and just go straight to number 4 of the order?
Sure. Essentially, in order to claim a bond, it requires an order of the commission. And so that the only way we can do it is to have an order and then specify that if they violate the order, then the director can claim the bond. So we have the order before us today. The order has the penalty specified. As I stated, there's no expectation that will be paid. So once that happens, I think it's a deadline of 35 days from the order becoming effective. Then we can claim the bond. And that's the standard procedure for these bond claims.
So I talked a little bit with AAG Davenport yesterday. I feel like I understand that some of this is due process and letting an operator have opportunity to remedy and fix their issues. But I think in this case, this feels unique to me in that this has been going on since 2017. There has been there's been no response, not even recalcitrance. It's just, they don't exist anymore. And I kind of feel like doing 1, 2, and 3 of the order first seems useless. And we kind of already know the outcome. And I feel like they've had plenty of time and due process to be able to come into compliance. And I was wanting to just go to number 4. So we issue the penalty. They haven't paid it. They're not going to pay it. And we just go straight to number 4, which is they're done doing business here in Colorado. They don't exist anyway. I'm not even sure it makes a difference. So that's kind of, I'm kind of struggling with why we're just going through the rote exercise of parts 1, 2, and 3 of this penalty notice. And so I'm happy to take feedback from you or your thoughts about this.
Sure. I think you hit on it earlier when you, I'm sorry to interrupt you there at the end. I think you hit on it a little bit earlier, but it is essentially a due process issue because when we do bond claims, they aren't purely situations like this. Situations like this have become common over the last few years, and our expectation is that they'll become more common as the landscape changes here. But we do also pursue bond claims in situations where there is someone on the other end. And in those situations, we want to make sure that even when the order gets approved, the operator has an opportunity to pay that penalty to conduct those corrective actions, such that they have every opportunity to cure whatever the non-compliance is prior to the commission claiming that bond. And it's in situations like this, I completely understand it's frustrating. We knew last fall, once we discovered they were bankrupt, that there was no chance of getting this penalty paid or getting the operator themselves to fix the situation on the ground. But it's simply the process. And in order for us to change that, I imagine that would require a rule or maybe even a statute change. And at that point, that would become kind of thorny for the due process issues. And that would be the limit of my commenting on that. I think that's more of something for AEG Davenport to comment on. But essentially, this is the process. I think the only sort of relief here is that it's not going to be a terribly long period. You know, the period provided in the order for them to pay the penalty is not long. And we intend to proceed with the bond claim process as soon as we've exhausted that period. We have been in contact with the bondholder. They're aware of the situation. They've asked us to transmit the order as soon as it's effective. So we do anticipate to follow up with that process as quickly as we can.
Thank you. And it also in my discussions with AAG Davenport yesterday, we kind of talked quite a bit about what does it actually take for the commission to pass go and not collect $200, so to speak, and go straight to, you've shown repetitive, consistent non-compliance and non-responsiveness so that we don't have to, I'm trying to use the right words here and be polite, because I know for some other folks that, you know, maybe they get to this situation or this point in time due to other things. You know, and it feels like the only way for us to do that is in an emergency situation where we feel like there's an emergency related to public health, safety, environment, health, wildlife, and that we don't actually have rules related to repetitive non-compliance and recalcitrance and non-responsiveness. And so I don't know if at some point this commission wants to consider thinking about rules related to those kinds of violations that allow us to remedy a problem faster than what appears to have happened here, which is has been going on since 2017. So food for thought. It doesn't mean to be answered today, but I find this frustrating. Thanks.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you so much, Mr. Kirshner, for the summary and the overview. I share Commissioner McGowan's frustration and asked a lot of the same questions, I think, to AAG Davenport, it sounds like. But yeah, I guess in part, I think you've already answered this question with the, you know, the no expectation that they will pay. But just to kind of generally understand in situations like this, if I'm understanding the order correctly, it is either if they don't pay or if they don't return to compliance, then those provisions in paragraph 4 of the order apply. Is that correct? And so even if somehow they came out of the woodwork and paid a portion of the penalty or engaged in some minor corrective actions, but not all the way up to compliance, we could still move to paragraph 4 in the order if those things didn't occur within that APA prescribed timeframe.
That's correct. And just not to get too far afield, but if this were a different type of situation in which we did have an operator who was, you know, a live person on the other end, who really made an honest effort, these orders do always include a paragraph. In this instance, it's paragraph 10 of the order section, that the commission has the right to alter or amend the order. Should we have a situation where an operator really does try in good faith to accomplish those corrective actions to pay that penalty and for whatever reason, force majeure or anything like that, they can't accomplish those things. So if if there is a situation like that, the order does contain provisions allowing us to make allowances for that. But in this situation, yes, if they don't complete either of those things, then the director is authorized to take the actions that are specified.
Okay, thank you. And then related, is there, I mean, I guess, okay, so we have the financial assurance, the 20,000, so that following this order could be claimed and applied towards the cost of plugging and abandoning that well location. You
Just
said
sorry to interrupt you. Just wanted to specify it has been plugged and abandoned. So the remaining work at the site is
Right,
just the
sorry,
reclamation work that we saw. That's okay.
Yes, thank you. Apologies. Okay, so this this would apply primarily to that reclamation. Let me think. There was a related question here that now all of a sudden my brain is not letting me remember. Okay. Sorry, I'm operating on very little sleep. Okay, I think I have another question, and I'm just gonna pass it to the next person because my brain's not working, so I apologize. But I think that the main thing I just wanted to note there. Oh, I'm sorry. Okay, I'm remembering now. I apologize. I'm really not functioning on all cylinders. So the last notice, if I understood correctly, is the last time we had contact with Alta Mesa was December of 2019, I think, where they signed off on one of the documents.
Yeah, so sorry, I'm interrupting you again. Go ahead.
Well, so I noted that, and then I noted that it was, I think, May of 2020, that then there was a realization that they had filed for bankruptcy, that we weren't noticed, et cetera. So yeah, go ahead and elaborate, and I have some follow-up questions.
Sure, and I can kind of talk through the timeline. We and reclamation staff, Ryan and Denise, were in contact with Alta Mesa through 2018 and 2019, trying to make sure that they were getting this work done. I don't want to introduce too much that isn't in the record here, but there were conversations throughout 2018, 2019 with Alta Mesa. And then at some point, they essentially just went dark. We never heard anything back. We had given them deadlines to respond. Because we really wanted them to get this work done. We wanted them to get this site reclaimed. And we just stopped hearing from them. So essentially, at that point, I no longer had my contact with Alta Mesa. They weren't responding. So I Googled to try and find a new contact, and it was late summer of last year, and I discovered that they'd gone bankrupt. So at that point, we engaged our bankruptcy counsel at the AG's office, and we learned the information that's included in the order and the presentation.
Okay, thank you. And so I guess the next question is maybe for AAG Davenport or Director Murphy, but I'm just curious, was there any reason that we needed to wait to get to this point? I'm trying to understand if we knew in around May of 2020, if I'm understanding the timeline correctly, that they did file for bankruptcy and we hadn't heard from them from December of 2019. I'm just kind of trying to understand why we're here in July now contemplating this matter, July of 2021. Thank you.
I can take some of that. So we didn't know in May 2020. We knew kind of more at the end of the summer, be it August or September. And we got the NOAV drafted and issued basically as soon as we could at that point. Some of that delay is just inherently due to our hearings process. I tried to lay out in the enforcement proceedings kind of, we file the application. It takes some time for the hearings unit to get us a notice back because we're not part of that unit. We're independent from that for a number of reasons. So some of that is the delay in getting a notice. And then some of that is on staff's part in that there was a publication error that set us back a few months as well. There's always going to be some delay kind of due to what I talked about earlier. There is a process that we have to undergo here, but a couple of those other delays, I think, were administrative on our part. There was a delay getting the notice out, and then there was a second delay due to the publication. So that kind of helps explain the process a little bit. But I can tell you, once we learned about the bankruptcy, we realized pretty quickly that our only option was to file an NOAV and to proceed through the process as quickly as we could. Oh, sorry, I should add that once we have an NOAV, we do give them a deadline, so 28 days to answer that NOAV as well. So there are some delays built into the process.
Okay. And it looks like inspections continued all the way through this May, correct, of 2021. So again, if you could maybe just help me understand, so if the NOAV was issued and clearly 28 days went by, could you just help me understand what was additionally, delaying the process of getting to this order?
Sure. I'm trying to find it now and I can't. So we filed the application for this matter to be heard pretty quickly. And I can, let me take a look at the order real quick. Yeah, so we filed the order. We filed the NOAV in this matter in November. We initially applied for a notice of hearing very soon after then. It was definitely in 2020. We got our initial notice in January of 2021. It was then essentially, we were trying to work with the hearings unit to get a status conference set as quickly as possible, to get a procedure. I would basically just say that there were some administrative delays here and leave it at that. But we really did attempt to move this through as quickly as we could. And the delays, I think the main delays here were in getting the notice of hearing issued and that publication error, which set us back a few months.
Okay, thank you. I appreciate all that explanation. And I'm just rereading this portion related to the bankruptcy that that the court confirmed Alta Mesa's plan in May of 2020. That's where I was getting that date, but that wasn't a conversation that you had with the court. Is that correct? That was, you didn't find out until later. And yeah, there might've been a few things going on at the end of the fall in 2020. So I understand the administrative delays that may have happened from that point, but thank you. I just wanted to better understand the timeline.
Sure, and if I can also shed a little bit of light, we do usually get notices in the event of operators' bankruptcies, and for whatever reason, we still don't know why we didn't get a notice in this one. So we scrambled as soon as we found out to get that NOAV issued so we could, essentially stop trying to work with an operator who was no longer there and proceed down this path.
Okay, thank you. And again, I don't want any of this to come off as criticism to the staff, just trying to understand kind of, what factors were coming into play, but thank you.
You're welcome.
Commissioner Messner, I'll recognize you in just a sec. I just want to make the comment that this seems awful complicated to clean up one bankrupt operator well that we've known about for upwards of multiple years. And I believe that it is incumbent on this commission to take this as a learning moment and uncomplicate that process. I agree with Commissioner McGowan that this full-time commission ought to have a rule in place that if we think a bond needs to be pulled, we go pull the bond after we give due process notice to the operator, and they can come in and explain why the bond ought not be pulled, period. And the complicated shenanigans of having to do an AOC and then they don't do it, and then an OFE and then they don't do it, and then give them more time. That just doesn't make any sense to me. So I, for one, would like to use this as an opportunity for us to provide direction to staff, direction to ourselves, that we ought to dig into enforcement, figure out what's working, figure out what's not working, and make sure that all of enforcement is working. Our rules are only as good as the enforcement that we put behind them. So that's my statement. John, Commissioner Messner, I think you probably had a more eloquent question.
But I actually concur very much with the statement, so thank you. I had a couple of questions around inclusions in the recommended order or in the staff's recommended order. One is it possible to put language in there that would also not authorize principals of the LP Alta Mesa to operate in the state of Colorado should they not pay their fine or come into compliance?
It is possible. We haven't asked for that here. We simply didn't find a reason to do that, but the commission's free to make oral modifications as it should see fit. We don't know who those partners are. That's some digging we'd have to do. I can tell you that we generally only include language like that in more egregious situations where an operator has kind of operated sort of in willful defiance of the rules, kind of over and above what we've seen here. But, and that's ultimately up to the commission. We're not asking for that in this case.
So that is something that I'll be asking for to the other commissioners to be included in this, to include the principles of this particular LP. And the second piece is in paragraphs, first line of paragraphs 4 and 5 of the staff's recommended order. It says, if Alta Mesa fails to pay the penalty or return to compliance within 35 days, is there any reason that that can't be an and?
There is no reason that can't be an and. And if the commission would like to make that modification, staff does not oppose that modification.
Okay, I'm going to make that suggestion as well. And then the only other question I have, and this just because, and it doesn't necessarily have to do with this, but understanding that, at least in my opinion, this appears to be an operator that does not operate their assets in good standing. Have we confirmed that there was a mechanical integrity test and the plugging and abandoning of this particular well was done properly?
I don't have the forms in front of me, but I have no indication that the plugging wasn't performed successfully. That's something I'm happy to check on, and I can report back to the commission in whatever form you'd like if I find anything sort of out of the ordinary. But I didn't see any indication through my review of the case that there was anything abnormal about the plugging.
I appreciate that. Those are the questions that I have at this point.
Sure.
Commissioner Gonzalez.
Thank you, Chair. Have we estimated the cost of the reclamation that we would be undertaking when we take over this well, this pad?
I don't think there's been a straight estimate done. I can tell you that in conversations with Denise Arthur, our anticipation is that the $20,000 bond would not be enough to get this reclaimed. If you have more questions about what it would take to do that, Dr. Arthur is available, and we can potentially hopefully make her a panelist and she can answer those questions if you do have more questions about what would be required.
No, I mean, I think that, I mean, if Dr. Arthur only has an estimate, you know, that's what we have to work with. I'd love to hear it if she does. If they haven't done that yet, I think that's an important consideration for me, just kind of in evaluating the level of egregiousness, if you will, for this one pad and the actions or the lack thereof of the operator Alta Mesa.
Sure, I'd be happy to ask Denise if we can make her a panelist.
If we're doing that, do other commissioners have further questions?
I think I'm here.
You are here.
Hello. Yes, I did look at the estimate and kind of all in. This is a location, Commissioner Gonzalez, it's going to need some removal of the gravel, some recontouring. That dirt work costs a lot as we go forward. It's relatively flat, as you could see. Kind of all in with weed control, ongoing monitoring is about $75,000. And so that would be multiple years of weed control, monitoring the revegetation, reseeding, so on and so forth, erosion controls.
Thank you, Dr. Arthur, for that information. Further questions? Commissioner Nanjapa?
Thank you, Mr. Chair. This is more of a bit of a technical thing, I think, related to Commissioner Messner's question, or with respect to changing the or to an and. I kind of asked the same question of AAG Davenport, and I guess where I landed was that if it's either a failure to pay the penalty or a failure to comply, in either situation, we go through the 4A through D and 5A through D. Is that, am I understanding that correctly? I guess I don't know if we need an and, because in either situation, a failure will lead us to paragraph 4 and paragraph 5. Is that correct?
AAG Davenport?
Thank you, Mr. Chair. My read was what was how Commissioner Nanjapa just related. It provides that if Alta Mesa fails to do either pay the penalty or return to compliance, then subparagraphs 4A through D and or 5A through C, I think it is, kick in. I think an and would also accomplish that and effectively not make a substantive change to the document.
Thank you.
Seeing no further questions, do we have a motion? Commissioner Messner.
Thank you, Mr. Chair. Just a procedural question. So a couple of suggestions that I made. One was the inclusion of the and instead of the or, and the second piece was to include potentially principles of Alpha Mesa or Alta Mesa LP. Do those require separate motions to include them in any kind of recommended order prior to that? Or I could make a motion including those changes, but I would like to hear deliberations on whether or not other commissioners agree with my inclusion of the principles.
Commissioner Messner, if I could interrupt for just a moment, just from a clarification standpoint for drafting purposes. Normally when we discuss things like principles of an organization, essentially what the paragraph says is it requires, if any of those principles desire to operate in Colorado, it requires them to come before the commission once again. Would I be correct in assuming that that's the provision you'd want to see?
That would be appropriate, I think, for me, my standpoint, yeah.
Okay, thank you.
AAG Davenport.
Thank you, Mr. Chair. The procedure that I will suggest is that the commission provide their thoughts, the remainder of the commissioners provide their thoughts on Commissioner Messner's edits, and then that there be a motion, just because if there's a motion first and then there's some disagreement with that, then the motion would need to be withdrawn or voted down. But I do recommend whenever a motion is made that it include all of the changes that the commissioner making the motion wishes to make to the order.
All right then, Commissioner Gonzalez and then Commissioner McGowan.
So a couple things. I've got, I do have an opinion on the principles kind of concept, and I've got some questions on that as well. So I'll start there. I guess my first question is, how do we define principles, right? Are principals executives at the committee, at the organization? Are principals, cut off at some level, officers of the organization specifically? Are they board of directors of the organization? Are they financial backers of the organization? In which case, with Alta Mesa, we're piercing back to any organization that would be backed by Riverstone or other financial backers. So I'm curious about kind of what it looks like for the principles and who we're seeking to exclude in this regard. And then the second part of that question is, what do we mean by if one of those principles wants to operate? If they are just employed by a company that's already operating, or may already be sharing a seat on a board with a company that's already operating in Colorado? How does that all work?
Commissioner Gonzalez, if I could jump in, I can simply read you what we usually use for boilerplate in this matter, and I can see how that goes. So the language that we use is that the order would require, and then it usually names specific people, but we could also say any principals of Alta Mesa Services LP, however they chose to craft it, but it requires those people to notify the commission if either individual or any entity of which either individual is a principal, majority owner, operational or general manager, or otherwise controls, applies for a permit or submits a Form 10 for the commission's approval, or either specified individual joins an existing entity and becomes the principal, majority owner, operational or general manager, or otherwise controls the existing entity. If any of those entities applies for a permit or submits a Form 10, the director may not approve the request. The request must come before the commission at a hearing, at which it may determine whether to grant the application, require a higher amount of financial assurance before granting the application, or deny the application. So that's the boilerplate that we usually use in these matters.
Okay, so you're looking at the actual kind of corporate structure and what's on file for the limited partnership associated specifically here with Alta Mesa Services.
That's correct.
Unless
And
you want to name individuals.
Correct. And just to make one change, that language I don't think we've used it since the rules changed, so that would be a Form 9 instead of a Form 10.
Gotcha. So, so that being said, I appreciate, and I had that same question about, how we deal with, persons, individuals who are leading these organizations that walk out of Colorado and leave a mess behind, right? We don't want those folks leading other organizations. And that's not uncommon within the oil and gas space, in my experience, is executives moving from one company to another after, a company sells or goes bankrupt or exits for whatever reason. So I appreciate the thought there. And I think that there are going to be times when that is appropriate to do, given the level of impact of this particular well pad and plugged well on it that we're talking about today, and a net to the staff and to the state and to our budget of $55,000. To me that doesn't reach the level that I think would be appropriate to exclude those individuals, going forward, just on the basis of our order today. So that's kind of where I stand in that regard. In terms of I don't know that the second part of that and compliance is possible within 35 days. Perhaps I'm wrong, but even in that light, I think that's a fine addition or a fine edit to the order itself. So kind of, I'd like to do a little more digging and maybe look at what we've done in the past with some of these, additions of principals, additions of individuals associated with these organizations, if we have in the past, and see what that looks like. But as it stands right now, I'm not comfortable for this particular matter just adding the former executives, the principals of this organization to this order as just to exclude them from further operations.
Commissioner McGowan, I can't remember who had their hand up next.
Thank you, Mr. Chair. So from just a technical question, do we need to include in this motion the changes that, is it AAG Kirshner? Sorry, is that your title?
Hearings Officer.
Hearings Officer Kirshner, sorry, asked for us to put in the proper dates and a change to paragraph 17. Does that need to be included in the motion? Okay, yes. So I'm not sure Commissioner Messner officially made the motion and it was seconded yet, but I would offer that as an amendment to his motion, a friendly amendment, if and when it's officially made. And to Commissioner Gonzalez's point, I think I understand what you're saying. And to me, in this particular case, less important is the severity of what has not been addressed by this company, but the fact that they simply walked away. And I'm not sure, I think that I would want the people who were involved in that behavior to come and talk to the commission before we allowed them to start a new business here in Colorado, personally. So I think we're not saying they can't operate. What we're saying, if I'm understanding how the language works, is they would have to come talk to the commission before they could submit their Form 1. Is that correct? Okay.
Commissioner Nanjapa, did you want to weigh in with thoughts?
Yeah, thank you, Mr. Chair. Yeah, that's exactly what Commissioner McGowan was saying. And just to kind of respond to the comments from Commissioner Gonzalez, I do appreciate, what he's getting at, but I would also agree that, given the language that Mr. Kirshner read to us, we would have the opportunity to hear and learn from those individuals why or what happened or et cetera, with respect to a new application that was before us or that kind of thing. And so I support the addition of the principles with the language as Mr. Kirshner read to us. And I also support, I'm ambivalent on the or and, but I'm also, I'm supportive of the addition of that language and of course the amendments that Mr. Kirshner recommended as well.
Thank you, Commissioner Nanjapa. I support Commissioner Messner's thoughts as well. Commissioner Messner, would you like to make a motion?
Maybe. This just got complicated. So I will make a motion to approve staff's recommended order with the modifications to include the principles of Alta Mesa LP, utilizing the language that hearing Officer Kirshner put on the record, as well as in sections 4 and 5 of the order, changing the word or to and between the term, the word penalty and return, and with the suggested modifications that hearing Officer Kirshner made regarding the dates of the recommended order. How'd I do?
Commissioner Messner, there was one more thing. I had asked that the paragraph, just one second. I had asked that paragraph 17 of the findings be struck. So that's the only other thing.
And I would include that in the motion as well.
Thank you.
Mr. Chair.
AG Davenport.
Thank you. I'm jumping in before there's a second to see if there's something that Commissioner Messner would like to add to his motion. And I'd actually like Enforcement Officer Kirshner's thoughts on this as well. Paragraph under the findings, discussion, and conclusions section, paragraph 4 also discusses exceptions and I think should be stricken as well.
I would have no objection to that.
And I'll include that in my motion.
Very good. We now have a motion. Do we have a second?
Second.
We now have a motion and a second. Do we have deliberations? Commissioner Gonzalez.
Thank you, Mr. Chair, and thanks for all the comments surrounding this. I am fully in favor with enforcing the penalty, with kicking Alta Mesa out of Colorado, to the extent that they exist or ever will again, specifically Alta Mesa Services LP. And that's another problem is that, Alta Mesa Services LP is a subsidiary of Alta Mesa Resources, which is a company that's basically owned and run by Riverstone Partners. And the further up the chain you get, the harder it is, I think, to really identify the parties who have control over this particular operation. I was in favor of the order as written, continue to be. I'm not in favor of putting the principles in here. I think it's too vague given what I know or what I've learned about this company here last few weeks reading through the materials. So in that light, as the motion has been extended or has been motioned, I guess, I'm not in favor of the motion as it's currently worded. And so as it currently stands in my deliberation, or I guess in this deliberation, what I'm saying is that I will not be voting for that motion so long as it includes that that principal language, just because we're talking about a well that's been abandoned, what we assume properly, and one well pad with $75,000 worth of work on it, supported by a $20,000 bond. And we'll have the opportunity to address those rules here coming up in October. That's kind of where I stand on the motion as it's been proposed to this commission.
Thank you, Commissioner Gonzalez. Further deliberation, Commissioner McGowan.
Thank you, Mr. Chair. Could I please have explained to me again this I'm going to call it cookie cutter language that we have about who's included as a principal. So to Commissioner Gonzalez's point, like how far up the food chain of responsibility does this include? And I'm wondering if there's a way for us to be clear and narrow about the language that we would want those folks directly involved in running Alta Mesa to come to the commission before they're allowed to operate here. And I don't know if that addresses Commissioner Gonzalez's concern about how wide that net is. And it might not, so it might be for naught, but I'm wondering if you could explain to me how broad, who gets pulled into that definition.
Sure. So to back up a couple of things, first of all, principles, as we're using it here, is a term of art. And I would imagine that there's case law specifically defining that term that I don't have in front of me today. So I'm not going to give you, the Black's definition or the case law definition of what a principle is here today. Normally, when we do this language, we narrow it to specific individuals. So the last time the commission saw this language off the top of my head was in Santa Fe Natural Resources. I think that was either last year or 2019. And we named a specific individual in that instance. It does obviously become a lot more difficult when you don't know who the quote unquote principals are. I don't have that information today. Obviously, Commissioner Gonzalez has looked into it. He's found some difficulty in ascertaining exactly who would be subject to that language. I'm not going to represent that I've done that work or how easy that work would be to identify those people. So in the language, we ask people to notify the commission if anyone who is a principal, and then we say majority owner, operational or general manager, or who otherwise controls an organization. Again, those are not exact terms. It does make it easier when we can name specific individuals. But I'm not prepared to name any individuals today. I haven't done that work.
Commissioner Messner.
Thank you, Mr. Chair. Thank you, Mr. Hearing Officer Kirschner, for that explanation. I still stand by the motion and acknowledge Commissioner Gonzalez's concerns around it. However, in my opinion, this is a message. And it is, to me, egregious to completely ignore commission rules and enforcement actions. And I don't want those type of operators operating in the state of Colorado as one commissioner, as a regulator of this industry for the protection of public health, safety, welfare, the environment, and wildlife resources. And certainly if a principal of Alta Mesa Services LP, wishes to operate in the state of Colorado again, then they certainly have the ability to come in front of this commission and explain why they can be a good operator in the state of Colorado. So it's not a prohibition, but I don't think that there's a dollar amount threshold or an egregious threshold that gives an operator a right to not follow the rules that are put forth by the COGCC.
Further deliberation? All right, Commissioner Nanjaba.
I was just going to concur with Commissioner Messner's last statement.
Seeing no further deliberation, I will call the vote. All those in favor of the motion signify by saying aye.
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 Those opposed, same sign.
Nay.
Okay. Motion passes 4-1. And I believe that docket number is now closed. With that, we do have a consent agenda. Does any commissioner have questions relative to the consent agenda? Seeing none, do we have a motion to approve consent agenda?
So moved. Second.
All right, we have a motion and a second quickly by Commissioner McGowan. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Consent agenda passes 5-0. With that, we are at the commissioner comment stage of our agenda. Do commissioners have comments? Commissioner McGowan.
Thank you, Mr. Chair. And I'm not actually sure that any of our public commenters from this morning are with us still. So I feel like we've heard several times comments about including, counterpoint views when we get presentations. I wish there were people still on the line, and maybe we can have a conversation about this at one of our planning meetings. I, as a commissioner, think that there are appropriate places and times for us to have differing viewpoints, but I also think there are points and times where it's appropriate for us to get specific presentations from specific folks, especially those who we regulate and are explaining to us how they apply those regulations and are trying to meet and comply with those regulations. So I'm not sure how to message to folks that I hear the message. I don't think it's appropriate in every single instance that we need somebody to offer a different viewpoint on something. And I hope folks also understand that just because something is glossy and pretty has music doesn't mean that I agree with everything or that I believe everything, just as I don't necessarily agree with the counterpoint all the time. And hopefully people give us some credit for, we have conversations and we listen, and our job is to take in all information and try to make good decisions. But I do think that it is appropriate for us to get presentations in some instances from the industry that we are regulating.
Appreciate that, Commissioner McGowan. I agree with both points, that having presentations from the community that we regulate, the industry, does make some sense. We have been on a learning curve. I also have heard, I think we've all heard, that we need to hear other presentations, but I've not heard any specifics. And so I would encourage folks to, heck, email me, give me a call if you've got some specific ideas of what it is that you think we need to hear. And perhaps we can reach out to some of the folks that have said this are frequent participators, and we've got their email addresses. And so maybe I'll try to reach out and see if we can get some specifics from them. Commissioner Gonzalez.
I think those are both excellent points. I think that, our job at this commission is to determine the credibility of those who come before us in our decision-making process. So I appreciate Commissioner McGowan's comments on that. And Chair Robbins, I appreciate your comments as well, that if folks want to hear specific things about specific dockets that we have coming up, or these informational pieces that we're bringing to the table, those are not secrets, right? It's not like we show up the day of and no one knows what we're going to be talking about. We highlight them and we signpost them along the way, and we'll do it again this Friday when we talk about whatever's coming up next. And so I've offered to numerous stakeholders along the way to reach out to me and give me a list of questions you'd like to see our presenters being asked. And also, if you have any specific experts who you'd like me to consider, if I'm the one, leading the informational doc or whomever it is that you'd like for us to consider to hear from on any topics. So I would love to hear some, some substantive suggestions in that regard. And perhaps that is a way that we can make these informational dockets better, more impactful and more informative. So I'd love to hear, as many sides as we can. And so, in that regard, it's got to be productive. It's got to be to the point. And again, if we're doing these informational dockets and you think we might need to hear from somebody important on the topic, please let us know.
Thanks, Commissioner Gonzalez. Commissioner Nanajapa?
Thank you, Mr. Chair. Yeah, I just wanted to, again, agree with what's being stated here. Our responsibility is to regulate the industry. And so getting that information so that we better understand it is a big part of that. Some of us are also doing visits with communities, as well as maybe seeing, operations on site and getting a sense for ourselves about the sounds and smells and everything else. We're hearing from individuals and from, community groups as well. And I, just to really appreciate Commissioner McGowan's comment that I hope everybody recognizes that we are taking all of these different pieces of information as part of doing our job. And we are not just singularly looking at pretty pictures and thinking that that is the one way and are ultimately just convinced. And to Commissioner Gonzalez's point, that is our role as well, is just to critically evaluate the information that comes before us. So just want to echo all of that. And when we have rulemaking, which we do have coming up, we will have broad stakeholder participation, and we'll have countering viewpoints, and we'll have opportunities for experts to come in and weigh in. So we will get to hear from a broader audience when it comes to something that we're actually making a decision on. And just want to also echo this idea of these informational dockets. One thing I did hear from a stakeholder very recently was, I think we had, I can't even remember if it was executive session or a work session, but I don't think it was a public session on bankruptcy and the way the bankruptcy laws work with respect to our ability to claim on certain things. And so, maybe that is a topic that we could visit that would help our broader stakeholders as well kind of understand these different matters. But I support the idea of specific suggestions so that we can hear from other folks as well.
Further comments? All right, seeing none, I believe we're looking for a motion to adjourn. Remind my fellow commissioners and our stakeholders that I think most of us are going to try to attend the 3 p.m. Session at CDPHE about greenhouse gas rulemaking. So we'll see you all there, and otherwise we'll look for a motion to adjourn.
So moved.
Second.
Great. Thanks for the great meeting. All those in favor of adjourning signify by saying aye.
Aye.
We are adjourned. Thanks, everybody.